Rosemary, are they related to Rosemary?
Yes.
Did either Juan, Sergio, or Richard go to the same party at Rosemary's house?
Richard and Juan did.
Do you remember today who arrived to Rosemary's house first, you or your two cousins?
I want to say me.
And do you remember whether or not your two cousins arrived together or separately?
I do not recall if they came together.
At one point, all three of you were at Rosemary's house?
Yes.
And that was Juan and Richard?
Richard.
Was Sergio there?
No.
Did there come a time when either Richard or Juan had communications with Sergio while the three of you were at Rosemary's house?
I believe they had communication with Gonzo. They were talking with Gonzo.
Okay, so was Gonzalo Guevara also at this party?
At the party, the first party I was at?
Yes.
No.
So, your two cousins had communications with Gonzo.
Yes.
And based on those communications, were you, Juan, and Richard going to leave Rosemary's party to go visit Gonzo and somebody else at a different location?
Yes.
While you were at Rosemary's party, it was a party, right?
Yes.
Drinking,
Yes.
eating,
Yes.
talking,
Yes.
like a regular family party.
Yeah.
Were you drinking at Rosemary's party?
Yes, I was.
Did there come a time when you, Richard, and Juan left Rosemary's party?
Yes.
How much do you think you had to drink at Rosemary's party from 7 o'clock that you got there till the time that you left?
Maybe like 5 or 6 beers.
And what type of beers were you drinking?
Bud Light.
And, okay, the regular 12 ounce?
Yeah, 12-ounce cans.
Cans or bottles?
Cans.
So you said about 5?
5 or 6.
5 or 6? Do you remember what time it was when the three of you left to meet up with Gonzo and whoever else you were going to meet?
I don't recall the exact time. I know it was after midnight, but because I know my wife already had left with my son back to the house, but I don't remember the exact time.
So can I presume that your wife had taken the car and driven back to your home with your son?
Yes.
And was she aware that you and Juan and Richard intended to go visit some other people and then come back?
Speculation.
No.
Well, I'm going to sustain. Don't speculate as to what someone else knew. You can rephrase the question.
So she left you there.
Yes.
When you left to go to, where did you go after you left the party at Rosemary's?
We stopped at the store first and picked up a 12-pack beer.
What store did you stop at?
It's a Chevron right off from 41.
How close was the Chevron off of 41 in relation to Rosemary's house?
A mile and a half.
Was that on the way to where it was that you were going?
Yes.
Let me ask you this. Were the three of you riding together?
Yes.
Whose car? Obviously not yours.
It was Richard's car.
Who drove?
Richard.
Did you know the location where the three of you were going to go?
I mean, I heard of the street before, but I had never been at that location, no.
And what street were you going to go?
Ocean Mist.
And you just told us that's not an area that you were familiar with?
I'd never been there before.
So the three of you go and get a 12-pack of beer. What type of beer?
Bud Light.
To take to this gathering.
Yes.
Do you know who was supposed to be at this gathering on Ocean Mist?
What they told me, I only knew Sergio and Gonzo. That's the only names they had told me.
That's who you were going to meet?
Yes.
And was the address 604 Ocean Mist?
They never told me the address.
When you arrived there, who was there?
It was Sergio, Gonzo, and Daniel that I had seen around before, but didn't really know him. And the other boy, it's Jose, but I didn't really know him at all.
Was it, how would you describe the area, residential area,
Yes,
homes? Was it a well-lit area or dark?
it was dark.
Was the home illuminated in any way?
Just the porch light was on.
Let me show you State's Exhibit number 5A. And ask you if you recognize that.
Yes,
Is that the home that you went with your two cousins after you left Rosemary's party?
yes,
And right here we see a porch light. Was that the only light that was illuminating the home?
yes,
Obviously, this light was not there, correct?
yes.
And when you arrived, where did Richard park?
That's the front of his car right there, right behind Sergio's car.
Right?
The
So
Nissan.
let me show you State's Exhibit 5. Is that a street view of the same home?
Yes,
And you've identified this gray car as Richard's?
yes,
And you said that it was parked behind Sergio's car.
yes,
You're familiar with his car.
yes,
And is this blue car the one that you refer to as Sergio's car?
yes.
Now, who did you tell me was already there when you, Richard, and Juan arrived at 604 Ocean Mist?
Sergio, Gonzo, Daniel, and Jose.
And where were they seating, or where were they in relation to the house?
They were on the left side of the porch. There's a table and chairs right there. They were all sitting there.
Let me show you State's Exhibit 10. Do you recognize that?
Yes,
Is that the area of the porch where you saw Sergio, Gonzo, and the two other gentlemen that you did not know at that time?
yes.
Could you please tell me if you remember when you first arrived where Sergio was?
I want to say he was sitting in the wicker chair because I know he was towards the back of by the window.
Okay, and how about Gonzo?
Gonzo was sitting in his bench, I believe.
And how about the other two?
And I think Jose was sitting on that single chair, and Daniel was sitting with Gonzo with him.
In, those two here?
Yeah, that chair there.
And the Sergio over there. All right, now, this isn't a court where everybody has assigned seats, right? It's a gathering.
Yeah.
What were they doing when you and Richard and Juan arrived?
Just drinking and talking, playing cards.
Was your group's intention to remain the rest of the night at the Ocean Mist address?
No,
What was your intention?
just to stop by and talk for a little bit, and that was about it.
And were you going back to your home, or were you going to go back to Rosemary's party?
Most likely go back to Rosemary's party.
Obviously, you, the three of you brought a 12-pack of beer. You don't go to a party empty-handed. Were you and the rest of the group drinking still at 604 Ocean Mist while you were there?
Yes,
Do you remember how much you drank at the Ocean Mist address while you were there?
probably 2 more beers.
Did you see whether any of the other individuals were drinking?
Like all of them?
Yes.
I mean, yeah, we were all drinking.
This is a party where you're trying to keep track of who was drinking and what they were drinking?
No,
While you were there, did you see anybody smoke marijuana or a blunt?
no,
While you were there, did you see anybody do any lines or bumps of cocaine?
no,
did there come a time where the three of you decided that you were going to go back to Rosemary's party?
Yes.
Approximately how long had you been at the Ocean Mist address before you all decided that you were going to go back to the party?
30, 45 minutes. It wasn't long.
Was there any attempt to get Sergio to leave with you all, or to leave, to go to Rosemary's house?
I know Juan was talking with him, but I don't know if he was trying to get him to go where we were going, but I know he was talking with him still after we already had said we were leaving.
And when you all are now deciding to leave after being at the 604 Ocean Mist address for about 35 minutes to 45 minutes, what steps did you take in order to let people know, okay, we're leaving?
Oh, we already had told him we were leaving, and I had stepped down up on the bottom step, on one of the bottom steps.
All
And
right.
I was just waiting on Juan to get done talking with Sergio.
All right, so let me show you State's Exhibit 5C. Do you recognize that?
Yes.
And in the front of the house, we have the steps leading up to the home,
Yes.
and there are 1, 2, 3, 4 steps before you get to the porch. Is that correct?
Yes.
And where was it that you were standing at the time when you are all trying to leave?
Around the bottom step.
The bottom step, let me, so I don't write on it, meaning on this step.
Yes.
And if you can tell us, where on the step were you standing? To the right, to the middle, or to the left of the step?
To the left.
Now, on this area right
Yeah,
here?
about right there, yes.
Do you remember where Richard was while you were waiting for Juan to finish talking with Sergio?
He was directly in front of me, but I believe he was still up on the porch, but right in front of me by that pole.
In this area right here where I'm pointing?
Yes.
Close to where there is like an orange bag?
Yes.
By the way, was that orange bag there when you guys were partying at 604?
I don't recall.
And where was Juan?
Juan was standing next to Sergio by the window, talking to him.
And so let me go back to 10. Was this the chair where you believe Juan, Sergio was sitting?
Yes.
And where was Juan in relation?
Just standing right next to him where that bucket's at, I believe.
Right
there.
on,
Yes.
right on this area?
Yes.
All right. And did you guys in fact leave the gathering at 604 Ocean Mist?
We were trying to,
Right.
but we didn't.
What happened that caused you not to leave 604 Ocean Mist and go back to your cousin Rosemary's?
I was standing there, and then I just heard somebody to lay down, show us your ID, or give me your IDs, and lay down. And I turned around, and all I seen was somebody running up beside the car. And I couldn't see him or nothing. All I could see was like, somebody running towards us.
All right.
Not really running, but coming.
All right. So, this is you've already told us that this is a residential area. Do you remember whether there was heavy traffic in that residential area on that Wednesday night, actually now, Thanksgiving morning, very, very early?
I do not remember.
Was there anything, oh, but let me ask you this, you're on the bottom step, which way are you facing? Are you facing the house, or are you facing the road?
I was facing the house. I was still looking at them, at the guys up top.
Which way was Richard facing, if you remember?
I believe he was facing the same way.
If, did you notice any lights go by or anything like that?
No.
So the first thing that you know, that attracts your attention is a voice saying something
To
to you.
lay down and give me his IDs, give us his IDs. our IDs.
The voice, was it male or female?
It was male.
Was there anything about the voice that was anything distinct about the voice?
No.
Did it have an accent? For example, I have a Hispanic accent. I like to say it's mild, but depending on the day, it's not as mild.
No.
That gave away the race, the ethnic background of the individual.
No.
Nondescript voice, but male.
Yes.
How about the tone? Was the person yelling? Was the person speaking softly? What can you tell us about the tone?
I mean, he wasn't yelling off the top of his lung, but he was speaking loudly.
Okay. And I know that your back was to the street when you heard the voice, but based on how loud the voice was, could you tell how close that voice was to you all? To you?
No, not at the moment, no.
All right. And when did that cause you to turn around?
Yes.
And when you turned around, did you see the individual that had spoken?
I mean, yeah, I seen like a silhouette, like somebody coming towards us.
And where was it that you first saw the silhouette?
Coming up by Sergio's car,
And
probably by the sidewalk.
so this area right here that I'm pointing out,
Yeah, around
for
that area.
purposes of the written record, is the sidewalk right by where the Hillsborough County Sheriff's Office light is. That's the sidewalk? Is that the sidewalk?
Yes, yes, sorry.
And you said by Sergio's car, is this area, is this area right by the car where
Yep.
you first noticed the silhouette?
Yes.
Okay? And now, what was it that you saw that individual do?
I just seen him coming at us, and then when I turned around, it felt like I got shot as soon as I turned around.
Okay?
And then I just heard Gonzo telling everybody to lay down,
All right,
to
let
listen.
me stop you right
Sorry.
here. So did you actually see the individual walking up?
Yes.
And was there anything, how fast or how slow was he walking, could you tell?
I mean, he wasn't running, but he was coming. I
It-
mean,
It wasn't a leisure,
no, it wasn't a leisure walk.
he wasn't saying up there,
No.
all right. And how close did he get to you before you got shot?
It felt like as soon as I seen him.
Where did you get shot?
I got shot in my right arm, and it went through my stomach from one end to the other.
And this is probably the wrong place to ask you, but I know I will forget later on. Did you get shot only once?
Yes.
And what organs were damaged because of this shot?
Hit my liver, hit a piece of my stomach, and I can't really tell you the rest. I know it hit some other things, but I know it hit a piece of my liver.
Did it come out the other side?
Yes.
When you got shot, what happened? Did you immediately fall? Did you stand there? What happened?
I was still standing. I just felt the burning going through my stomach. And then that's when I heard Gonzo telling everybody just to listen, lay down, get the IDs. And then I just laid down and I put my head down. And I guess from the
All
blood
right,
loss.
let me stop there. So, immediately after you get shot, are you still facing the street now when you get shot?
Yes, I turned around.
And what area of your body did the shot hit?
First,
Yes.
it hit my arm,
All right. And you're pointing to your arm, but can you tell me which arm it is that?
my right arm.
Your right arm?
Yes.
And as you were shot, that's when you hear Gonzo telling everybody, hey, lay down, get on the porch and lay down, or words to that effect.
Yes.
Now, on the bottom step, are you being illuminated? Do you have the same light as the people that are up on the porch?
Objection, speculation.
He was on the porch, Your Honor.
Don't speculate, only if you know, don't guess.
I couldn't tell you.
And did you in fact lay down?
Yes.
And where did you lay down?
If I recall, I got back up on the porch and lay down in the beginning, like right where Richard was standing to begin with.
Okay. So let me show you State's Exhibit 5C. Is that the porch?
Yes.
And when you were shot, were you still on that first rung of the stairs?
Yes.
And how far did you climb up?
Just right at the beginning, right there to the left side.
All right. Using 5C as a guide, now showing you 9. Could you please tell us where it was that you laid down?
I want to say right here somewhere, right in the beginning by 7, by where the marker 7's at.
And when you laid down, face down?
Yes.
Were your eyes open or closed?
They were closed.
As you are laying there, even though your eyes are closed, could you still hear whether or not the individual that shot you got closer or came up onto the porch?
I heard footsteps, but I couldn't tell you if they were his or not, but I heard footsteps walking past me.
Was there anybody else out there other than those of you who were on the porch and the one person that you saw coming towards you who had voiced the commands to lay down?
No.
The steps that you heard, how did you hear the steps of the individual getting onto the porch?
Yes.
And did you hear any more commands?
Just the give me your IDs and lay down. That's the only ones I remember.
And do you remember whether or not you heard any additional shots after you laid down, obeying the commands of the individual and the recommendation of Gonzo?
I heard a couple more shots, yes.
Do you know, since you laid down and your eyes were closed, whether any of the other men that were on that porch also laid down?
I didn't actually see them, I just heard Gonzo telling everybody to do it.
Did you pass out?
Yes, I did.
You said that you heard a couple of additional shots. Do you remember, or can you tell us today, whether they were in rapid succession or whether there appeared to be a pause?
It appeared to be a pause.
Did you come to on your own, or were you, I don't want to use the word revived, but were you brought back by members of the fire rescue?
I came back to my own, but the cops and the people were there already, the ambulance.
Was the shooter still there?
No.
And at the time that you came to, did you see your cousins or the other young men that you had been on the porch with before the shooting still there?
All I seen was Richard was laying there, bleeding from his head, and then I seen Sergio was up past him, and Juan was like by Sergio, trying to talk to him, or trying to help him. That's the only 3 I seen.
And did the fire rescue arrived and started tending to their injuries?
Yes.
Were you yourself transported to the hospital?
Yes.
Which hospital were you transported
Tampa
to?
General.
And how long were you at the Tampa General Hospital?
Almost 2 months.
After the 2 months in the hospital, did you have to have any type of therapy?
I had physical therapy.
Have you seen Richard Cantu since the shooting?
Yes.
How often do you see him now?
Now, maybe once a month.
Is he driving?
No.
Is he working?
No.
Can you have the same type of conversations with him today that you did back in 2010?
No.
Objection, same objection.
I do have.
Approach.
How long do you think it was that you were actually seeing, or that you actually had the opportunity to see the person in silhouette that shot you?
Felt like seconds, maybe 2.
Did you ever see the person's face?
No.
Can you tell us his height?
No.
How about the physical composition? Thin, fat, nondescript?
He wasn't fat, but he wasn't thin either, so I'd say medium built.
And because you've already told us that you only saw a silhouette, would it be a fair assumption that you do not know who shot you?
Yes.
May I have a moment, Judge? I pass the witness, Your Honor.
All right, cross-examination.
Good morning, sir.
Good morning.
When, after you get shot, and you hear Gonzalo say, you know, hey, everybody lay down, give your IDs, and you get up on the porch and you lay down.
Yes.
I think that you said that you believe after you heard what sounded to you like a couple shots, you passed out.
Yes.
When you come to, the police are already there, ambulance people are getting there or already there, correct?
Yes.
And when you come to, I think you said to us that you saw Richard and you could see Sergio with Juan trying to talk to Sergio,
Yes.
correct? Were they to your right on the porch? If I show, I'm
I'm-
bad with right and left, so
If
hold
I'm
on.
looking at the house,
Let me show you. I'm gonna use 5, okay? As we're looking at that house, I think you told us earlier that you were in that area where marker 7 was, correct?
yes.
Okay, were they to the right of you as we look at the house?
As I came back to came back?
Yes.
Yes, they were to the right of me.
They were to the right of you?
Yes.
Were they at the end, can you see, Mr. Galan, as we stare at this picture, the rightmost part of the porch, is that where they were at?
Sergio was there and Richard was like before him.
Before him?
Yes.
Okay, so they were to the right of the door and more toward where the right railing would be.
Yes.
Okay. when, and I think you identified, let me go back to 5. This gray car, that's Richard's car.
Yes.
That's the car that you, Juan, and Richard came in, right?
Yes.
And Richard was driving, right?
Yes.
You had talked to us, I think, earlier, and you said that at Rosemary's party, you had had probably about 5 or 6 beers, Bud Lights.
Yes.
And then when you all got to this party and you had the 12-pack, you probably had maybe 2 more,
Yes.
correct? Do you recall that you were feeling buzzed but good enough to drive?
I mean, I was buzzed, yeah, but I wasn't drunk. I believe
Right.
I could have drove, yes.
Yeah, you felt like you were buzzed, but you felt like, I'm not drunk. If I needed to drive, I could drive.
Yes.
When you were sitting on this bottom rung that you've identified to us over here on the left side,
Yes.
that bottom step, when you were standing there and you're facing the house and you're facing where your cousins are and really their friends are, do you ever see any of them get up and go, hey, who's that, or anything like that?
No.
So the first thing that alerts you to turn around is you hear this voice saying, give me your IDs, lay down on the ground.
Yes.
And the voice is saying it, you know, like loud, kind of like I'm being right now, loud,
Yes.
and kind of forceful.
Yes.
And this silhouette that's walking is walking quickly.
Yes.
They're walking quickly to the porch, and they're saying this while they're walking quickly, correct?
Yes.
And all you see basically is kind of like a black outline of a person.
Yes.
And the voice is what tells you that's a man, correct?
Yes.
And do you recall thinking that in that brief 2 seconds that you were able to see this silhouette, it kind of looked like maybe they had a beard?
Yes.
But beyond that, you really couldn't see. You couldn't see the race of the person. You couldn't see hair color, nothing.
No.
Because this street is so dark. That area outside that porch is that dark, correct?
Yes.
And that gunshot that hits you and causes your injuries, that's a really loud gunshot, right?
Yeah. Yes, it was loud.
And so the last thing you expected when you were standing on that porch was to have anybody come up and do anything like this to you, correct?
Yeah. Yes.
And if any of the people on the porch, as you were looking at them, waiting for Richard and Juan to come so that you could go back out to Richard's car and go back to Rosemary's party, if you would have seen any of the other guys on the porch make reference to who's that, who's coming up, you would have turned to look, right?
Yes.
And that didn't happen, correct?
Not that I recall. Not that I heard him say.
And you never heard this male voice at any time prior to you passing out. You never heard this male voice ask for anything, anybody, by nickname or by name,
I did
correct?
not. I
You
did not.
Your Honor, if I could have a second.
Absolutely.
I don't have any other questions. Thank you.
Redirect.
No, Your Honor, thank you.
May this witness be excused?
Yes, sir.
And by the defense?
Yes, Your Honor.
Thank you, sir. You may step down. You may be excused as a witness at this time. I'll ask the state to call your next witness.
Jason Brando.
Jason Brando?
Yes.
Thank you. Mr. Brando, good morning and welcome. If you'll come forward to be sworn wherever you're comfortable, if you'll face me and raise your right hand. Thank you. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. If you'll follow the bailiff around to the ramp that leads up to the witness chair, please watch your step. Go ahead, have a seat, make yourself comfortable. That microphone does adjust.
Thank you, sir.
You're welcome.
Good morning, sir.
Good morning.
Please state your name.
Jason Brando.
Are you in the construction industry now?
Yes, I am.
Back on November 25th and 26th and through the rest of the month, where were you working?
Of what year?
I'm sorry. Good question. Of 2010.
I was a crime scene investigator with the Hillsborough County Sheriff's Office.
And what were your responsibilities in that regard?
As a crime scene investigator, we're tasked to document the crime scene with photography, note-taking, evidence collection, and processing.
How long had you been a crime scene investigator as of 2010, approximately?
About 6 years.
In that capacity, did you participate in the execution of a search warrant at the Keetley home at 4935 Bonita Drive?
Yes.
Did you take some photographs during your time at the scene?
Yes.
And did you collect items of evidence?
Yes.
When you collected items of evidence, what was your procedure? What did you do with them?
Once we get to the scene, we photograph the items of evidence, and then we package them. We put on gloves, package the evidence in our evidence packaging, whether it be envelopes and bags, seal them, put our initials, date, and time on there, and turn into evidence.
And does each Hillsborough County Sheriff's Office investigation have its own unique Sheriff's Office case number?
Yes.
And was one assigned to this case?
Yes.
And would all the packaging of items that you collected during the execution of a search warrant bear that case number and your name and your identification number?
Yes.
And that assists you many years later in identifying items that you collected from a variety of locations, in this case from the Keetley home?
Yes.
All right, thank you. Let me show you what's in evidence of State's Exhibit number 142. Do you recognize that is a shot from the gate looking towards the Keetley home that you assisted in the execution of the search warrant?
Yes.
And on the other side of the gate, showing you State's Exhibit number 143, is that the same residence that you searched inside?
Yes, that's just inside the fence line.
Showing you what's in evidence of State's Exhibit number 103. Do you recognize that as the first room that you enter into through that front door?
Yes.
And already in evidence as 102, close up to some items on a table in that foyer inside that main doorway?
Yes, sir.
Okay. Now, were other crime scene technicians working in processing the scene before your arrival?
Yes.
So were there other photographs taken by other crime scene technicians?
Yes.
Okay. On the floor of that foyer, did you observe any targets used for shooting?
Yes.
Showing you, well, let me do it this way. 103A and B. You recognize these as photographs you took of items in the foyer of the Keetley home that day?
Yes.
Judging with States 103 and 103A and B in them.
Any objection?
Yeah, no, except for those previously lodged.
All right, they'll be admitted at this time.
Publishing states 103A. And what is shown at the bottom of this photograph as I've enlarged it?
That's the target packaging that was found just on the other side of the chair in that foyer area.
And states 103B. Let me back it out a little bit. Is that a close-up of the same target being packaged?
Yes.
During the course of your participation in the search of the Keetley residence at that time, did you also conduct, assist in the search of the living room or family room of that home?
Yes.
Let me show you photographs that are already in evidence. States Exhibit number 105. Do you recognize that as the photograph of the living room looking towards the kitchen?
Yes.
And was this in the condition, approximate condition when you were there?
Yes.
States Exhibit number 106, you recognize this as a photograph taken approximately from the kitchen looking into the living room?
Yes.
And was there an item of evidence on the coffee table at the location I'm pointing with a pin that you collected and placed into evidence?
Yes, there's a laptop computer.
Showing you States Exhibit 106A, is that a close-up of the laptop computer on that coffee table?
Yes.
And did you package it in the manner you described previously and place it into evidence?
Yes.
Now, do you do any type of testing or downloading or anything like that of such an item?
No.
Showing you what's been marked for identification, is States Exhibit number 107. In preparation for your appearance at trial as a witness, have you seen this item recently?
Yes.
And did you have an opportunity to inspect it?
Yes.
And were you able to, from interior packaging and markings on the interior packaging, were you able to recognize and identify this item?
Yes.
And you recognize this item, States Exhibit number 107, as that laptop computer found on the coffee table and taken into evidence by yourself during the course of your participation in the search warrant execution on November 28th of 2010.
Yes.
Your Honor, move States 107 into evidence.
None other than those previously.
Raised. This time.
I want to show you what's in evidence already as States Exhibit 110. Do you recognize that as a photograph of part of the kitchen of the Keetley residence?
Yes.
Let me show you photographs 109 and 111 from top to bottom and ask you if you recognize those photographs.
Yes.
Each of those two photographs fairly and accurately represent portions of the kitchen and items strewn about the kitchen as they appeared during your participation in the execution of the court-authorized search warrant on that date.
Yes.
Your Honor, I move States 109 and 111 into evidence.
Can I double check this? None other than previously mentioned.
All right, they will be admitted at this time.
Publishing for you States 109. Is this a view from the kitchen table looking out towards the countertop that would lead into the living room?
Yes.
Specifically drawing your attention to an item on the right as we're looking at the countertop. Was there some type of composite notebook on the countertop at the time that you were there inside during the search warrant?
Yes.
Showing you State's Exhibit 111. Is that a closer view of that same countertop with the composite book?
Yes, it is.
And was that composite notebook collected and taken into evidence and packaged and identified in the same manner you described previously?
Yes.
Showing you what's been marked for identification is State's Exhibit number 115. In anticipation of trial, did you have the opportunity to look at this exhibit before today?
Yes.
And do you recognize from the packaging and previous packaging that's contained within the outer packaging, from your markings and identification numbers, that is in fact the actual composite notebook shown in the previous two photographs from the kitchen counter from the Keetley residence?
Yes.
Your Honor, move State's Exhibit 115 into evidence.
None other than those previously raised.
All right, it will be admitted.
May I publish?
You may publish.
By just showing it to the jury?
Yeah, don't give it to him. You can either show it or you can put it on the OMO if you wish.
Yes, sir. Okay. So, prior to, well, did you process any interior pages on this composite, or excuse me, composition notebook to try to locate and preserve fingerprints that may be on any interior pages?
Yes.
And what kind of process did you use?
It's a chemical process called anhydrine.
Does that stain the pages in any regard?
It does.
Prior to your processing interior pages for fingerprints in that manner, did you take any photographs of the pages so that you could later preserve what the pages looked before the processing?
Yes.
Let me show you what's been marked for identification in State's Exhibits 115A, B, and C. And I ask you if you recognize these three photographs.
Yes.
And are those photographs of three separate interior pages of the composition book, Exhibit 115, that you took prior to your application of an anhydrine in an attempt to identify or locate and preserve fingerprints?
Yes, it's before and after, yes.
Okay. Your Honor, I move States 115A, B, and C into evidence.
Other than the previously raised objection, no objection.
All right, they'll be admitted at this time.
So I have the marble composition book number 115 on the screen presently, and opening it up, just the outward cover of it. Is the staining that you've indicated that was a result of an anhydride application observable today?
Yes.
Okay. Showing you State's Exhibit 115A. Did the staining, however, change any of, well, I'm sorry. State's Exhibit 115A, let me ask you, at the top of that page is still the word Bailon, B-A-I-L-O-N, with 507 Ocean Mist. Is that correct for the
Yes.
record? Okay. And 115B, I'm showing you Immediately after the application, does it leave a more pinkish tone on the paper?
Yes.
However, today, almost 9.5 years later, it turns into a darker tan?
Correct.
Okay. And the photograph I'm showing you, let me step out a little bit with it. At the bottom, is this a measuring tape that you placed on there at the time you took the photograph?
Yes, on the right side there's a scale, on the bottom as well as a scale. Basically it has my name, my initials on there, the date, and the case number of this front page of the composition notebook.
And JB, your initials, Jason, for Jason Brando?
Yes.
And 209331 pertains to what?
My ID number.
Okay. And 41513, would that be the date of what?
With the date of which I processed the notebook for possible fingerprints.
Okay. Were you able to observe a possible fingerprint on the page that I'm showing you that's photographed in State's Exhibit 115B?
Yes.
And is that in the upper left-hand corner at the location I'm pointing?
Yes, sir.
Okay. Now, as a crime scene technician, do you do anything to compare possible fingerprints with known fingerprints?
No.
Do you have employees within the sheriff's office who are trained for that task?
Yes.
Okay. So, describe to the jury, please, the steps that you would have taken after an application, well, I'm sorry, the ninhydrin process that you described. What does it do to the surface of the paper to illuminate or enhance the presence of fingerprints if they are present?
We use a chemical called ninhydrin, and it acts with the amino acids on your fingerprints on porous items such as paper. Basically, what we do on this step here is we photograph or scan the notebook prior to processing, which was the first photo you've seen, and then after that, after the processing is done, well, the way the process happens is we have a chemical called ninhydrin. We then spray or dip the notebook. In this case, I sprayed it. Once those are dry, it turns, if it reacts to the amino acids on your fingerprints and turns into like what we call a Runeman's purple. And this is what the color you see on the top of the page is, that purplish color. Basically, like, again, it dyes the amino acids on your fingerprints. After that happens, if we see any type of chemical reaction, we then scan it in again as well for later identification by our latent print section.
When you say scan it in, what do you mean?
Just take instead of photographing the image, we scan it on a scanner and then send it over to our latent section to get identified.
Is it electronically transferred then to the fingerprint people who do the comparisons?
Yes.
And was that done in this case with what appears to have been a fingerprint on the upper left-hand corner of that page?
Yes.
Okay. May I have a moment, Your Honor, please?
Yeah.
Showing you what's in evidence is 115C. Is that another page of the notebook that you applied the ninhydrin process?
Yeah, that's the inside cover of the notebook.
Okay. All right, and did the ninhydrin process illuminate or enhance what appeared to be a fingerprint in the upper right-hand corner of that inside front cover?
Yes.
Now, showing you next to each other, 115C on the left and 115B on the right. Does that show the relative locations of the two apparent fingerprints that the ninhydrin enhance on the interior left cover and on the first page upper left-hand corner?
Yes.
Now, when you processed it for an anhydrine, with an anhydrine, did you have to retrieve it from the secure evidence facility at the sheriff's office?
Yes.
And when you retrieved it, was it in that same sealed container that you had entered it into evidence in?
Yes.
Had there been any apparent entry into that container prior to you checking it out?
Not that I know of.
The system that you scanned the images into, is that called Veripix?
Yes.
That same kitchen counter upon which you photographed the composition book and retrieved the composition book from, did you take additional photographs of items on that counter?
Yes.
I want to show you what's been marked for identification as States Exhibit 118, 118A, 118B, 118C. Ask you if you recognize these 4 photographs.
Yes.
Do they fairly and accurately depict items that were observed and collected from that same kitchen counter from which you obtained and packaged the composition notebook?
Yes.
Your Honor, move States 18, 118, A, B, and C in that.
Anything additional?
Nothing additional.
They'll be admitted.
I think I misspoke. I don't think I said 118, but I want to say 118, 118A, 118B, and 118C.
So it's 4 of them.
There are 4 of them, yes, sir.
All right, they'll be admitted.
Thank you. May I publish?
You may.
Is this a view of that same counter taken from the opposite or the living room side looking into the kitchen?
Yes.
States Exhibit 118A. Was there a folded piece of paper found near a rock garden on that counter?
Yes.
Is it shown in that exhibit?
Yes.
States Exhibit number 118B. Is that a close-up of that folded piece of paper?
Yes.
And did you take an actual photograph of, after unfolding this piece of paper, of the image on the interior side of this piece of paper?
Yes.
States Exhibit 118C, is that a photograph you took of that piece of paper next to the rock garden on the kitchen counter once you unfolded and opened it?
Yes.
Showing you package and contents marked 118D. Ask you, in anticipation of your testimony today, have you observed that exhibit previously, a week or so ago?
Yes.
And do you recognize that as the piece of paper that is shown in the previous photographs, 118, 118A through C inclusive?
Yes.
Your Honor, move States Exhibit 118B into evidence.
Only subject to previous objections.
They'll be admitted.
And let me publish it and draw your attention to the bottom of it. On the bottom left-hand side of it, is there an internet address of HCS pertaining to state of Florida inmate photos?
Yes.
And is there a date on the right-hand side?
Yes, there is.
And is that 10/6 or October 6 of 2010?
Correct. Yes, sir.
Do you have any personal knowledge as to who, is that a Hispanic male, photograph of a Hispanic male, sir?
Yes.
And do you have any Do you have any knowledge, personal knowledge of who that person is?
No.
Was there a computer printer on a counter in the kitchen?
Yes.
Showing you what's been marked for identification, it states Exhibit 119 and 120 from top to bottom. You recognize those photographs, sir?
Yes.
You recognize those photographs to be photographs of the computer printer on the kitchen counter of the Keetley home as seen by you at the time of the execution of the search warrant on November 28th of 2010.
Yes.
I move states Exhibit 100 and I lost track. 119 and 120 in evidence.
Subject to previous objection.
All right, they'll be admitted.
And as I'm publishing the photograph and pointing to it, is this the printer with a bag of Lay's potato chips on top?
Yes.
Now, immediately to the left, is there an entryway through some curtains into an adjacent room?
Yes.
And was that adjacent room a bedroom?
Yeah, makeshift bedroom. Yes.
Okay. With a hospital bed in it?
Yes.
Showing you 120, is that a closer view of that same computer printer?
Yes.
Okay. On top of the computer printer, did you find any printouts of any Hillsborough County Sheriff's Office arrest records?
Yes.
Showing you Exhibit 120A, is that a close-up photograph of the arrest records that you observed on that printer at the time of your participation in the execution of the search warrant?
Yes.
I move states 120A into evidence.
None other than subject to previous objection.
Okay, it will be admitted.
Did you collect the items of paperwork, Hillsborough County Sheriff's Office arrest records that you observed and photographed on top of the computer printer in the Keetley kitchen?
Yes.
Showing you what's been marked for identification, it states Exhibit number 120B. And have you had the opportunity, in anticipation of your trial testimony, to view these documents and the packaging contained within that package, to refresh your memory of these documents?
Yes.
And are those the actual Hillsborough County Sheriff's Office arrest records that were found on the computer printer in the Keetley kitchen on November 28th of 2010?
Yes.
Your Honor, move states Exhibit 120, I think it's B, into evidence.
Other than previously
Not
discussed?
other than previously, yes.
All right, it'll be admitted.
On the first page of that, is that Hillsborough County Sheriff's Office of that Exhibit 120B, arrest inquiry, I should say, for an Armando Guerra.
Yes.
And on the front page, is there a photograph?
Yes.
And is there an indication of ethnicity with a colon followed by the letter H?
Yes.
And that's in a box, is it correct, for the record purposes, immediately next to the photograph?
Yes.
Okay. And was there also a arrest inquiry for an individual by the name of Daniel Wayne Ellswick?
Yes.
And also an arrest inquiry for the name of a Paul Ellswick?
Yes.
Okay. At the very, directing your attention to the very bottom of the front page that pertains to Armando Guerra, and at the bottom, is there an internet address pertaining to the Hillsborough County Sheriff's Office?
Yes.
At the far right, is there an abbreviate, a date?
Yes.
And is that 4/12/200 or 2010?
Yes.
All right. Was there a pantry contained within the kitchen?
Yes.
Okay. Did you take some photographs of that pantry and the interior of the pantry?
Yes.
Can I have a second, please?
Yes.
I want to show you what's been marked for identification as states exhibits number 121, 122, and 123. From top to bottom. I ask you if those are photographs that you took of the pantry and items contained within the pantry that you observed at the time of the search warrant.
Yes.
Your Honor, move states 121, 122, and 123 in evidence.
Anything additional?
Nothing in addition, Your Honor, than previously raised.
All right, they will be admitted.
Showing you states exhibit number 121 is at the back side, well, the showing you among other things, a target attached to the pantry door.
Yes.
Showing you 122 is that an interior view of the top shelves of the pantry.
Yes.
Did you find a ammunition clip within that shelf?
Yes.
Is that shown the location where I'm pointing?
Yes.
Showing you states 123, is that a close-up of that same clip?
Yes.
Was that actually a Glock ammunition clip, do you
Yes.
recall? And did you collect that clip and take it into evidence?
Yes.
Showing you what's been marked for identification as states exhibit number 123. Again, in anticipation of trial, have you seen that exhibit recently?
Yes.
Do you recognize it from the exterior and interior markings on the items contained within?
Yes.
Is that actually the Glock ammunition clip that you located and collected from the kitchen pantry during the execution of the search warrant of the Keetley residence?
Yes.
Your Honor, move states 123A into evidence.
Any additional objections?
Nothing additional than previously raised.
They will be admitted.
Can you see the imprimatur of the Glock insignia on the bottom of it, sir? It's not
Yes.
illuminated very well, but, okay. I'm showing you what's in evidence as states exhibit number 124. Do you see that same computer printer on the right side of this photograph that we've had photographs just a minute ago in?
Yes.
Is this that same entry into the adjacent room that was being used as a bedroom?
Yes.
Okay. me show you what's in evidence as State's Exhibit number 128. During the time that you were participating in the execution of the search warrant, did you observe in that room adjacent to the kitchen, the room that had been used as a bedroom, a drum magazine and a gun case including a large assault rifle?
Yes.
The drum magazine, is it located on a table at the location where I'm pointing to?
Yes, sir.
And the gun case, is it shown at the bottom here in the location where I'm pointing?
Yes.
States 129. Is that a close-up of the same Glock? I'm sorry, not Glock, but drum magazine?
Yes, sir.
Did you collect that drum magazine and place it in evidence and mark it as you've indicated before?
Yes.
Showing you what's been marked for identification in State's Exhibit number 129A. Have you seen that exhibit in anticipation of trial and preparation?
Yes.
You recognize that as containing that exhibit
Yes.
being the same drum magazine collected from the bedroom adjacent to the kitchen and shown in State's Exhibit number 129.
Yes.
Your Honor, move States 129A into evidence.
Anything additional?
Nothing additional to previously raised.
All right, it will be admitted at this time.
I have one more to bail.
Yes.
Now, was there a rifle that was semi-automatic rifle that was found in that same room adjacent to the kitchen?
Yes.
Do you recall where that was located?
I believe it may be in a closet.
All right. And
Mr. Crooner, it's about the time for the morning break. Is now a good time to go ahead and...
yes, sir.
All right. Ladies and gentlemen, we're going to take our morning break. Please do not discuss the case amongst yourselves or with anyone else. Please do not do any research related to the case, and please avoid all reports of the case outside of the courtroom. All rise for the jury. Jury has exited. Everyone may be seated. I try to take the morning break around 10:30 so that it gives us, when they come back, to about 12:30, another hour and a half. The witness may step down, enjoy the break. Please do not discuss your testimony with any of the attorneys unless all the attorneys from both sides are present. You're welcome. Roughly, Mr. Pruner, about how much longer on direct?
25 minutes. Maybe.
Okay, so and then we'll do the cross. We'll see where we're at, but maybe we'll get another witness in before the lunch break.
Yes, sir.
All right, thank you.
Our next witness is going to be Karen Noble. She is the handwriting expert. We already have some exhibits that have already been introduced into evidence. There were some other additional things that she looked at, including Delta business records, which I've shown Ms. Gowdy. I've taken some stuff out which I believe are objectionable, and I would like to introduce them at this time, or before she takes the stand. I believe Ms. Gowdy has an objection.
I do. I don't find them relevant. What's relevant here is the exemplars. I actually went out of my way and met with Detective Lugo, and when Mr. Keetley complied and gave them the exemplars. You saw me open where I put that composition book papers on the Elmo, showed them to the jury, okay? So at the end of the day, I don't understand why we've got to introduce Delta business records. There were a lot of previous handwriting of Mr. Keetley prior to the exemplars that were given that they could use, and I think that this is kind of a way to put in some Delta business records to try to then be able to say he had some sort of special skill or something like that. And
What are
I'm
the Delta
objecting to
business
it.
records?
Judge, before we obtained the exemplars, Ms. Nobles was provided with different business documents that had the defendant's handwriting on it, and it was part of the work that she did. When reviewing that, that is part of what she formulated her opinion that he is probably the writer. And so those documents, there were other letters that we received from jail.
Can they be redacted so
I
that they're
did.
not Delta business records?
Judge, I think it's important that they know that we not only, the exemplars are stuff that he knows he's writing for this specific purpose. She had samples prior to that he could not try to change his handwriting, that actually showed his handwriting in the normal course of business. That is where he worked, was Delta. They're self-authenticating. They are relevant because they were part of her examination in determining whether or not the handwriting in the composition notebook.
I hear you, and I get all that. I'm just trying to satisfy the concern of the defense, which is that might give some other impression that he had special skills because of where the records come from.
Well, Judge, he was a mechanic for Delta Airlines. That's part of his experience, and that is what he did. I think that's going to come in through other avenues. His parents probably are going to take the stand. I don't see how that is so objectionable.
Probably, they might not.
They may not, but how is that? They are relevant for her examination. I can tell you.
Not saying they come in. We just take off what employer. These are we redact and say these are prior employment records. Period.
And Judge, Ms. Towers already has testified that he was a Delta employee and that he was a mechanic there, so I don't see how it's prejudicial. But it does show that these were documents that he would have filled out during the normal course of business. And I can tell you what I did redact out of there. There was mention of a prior incident involving threats. I've taken that out at the workplace. There were some in his application, what he had been previously convicted of. I've redacted that out. The only purpose of these records is to show that she had a sample of his handwriting that he filled out using his regular handwriting. The exemplars, it is a source that she uses as part of her opinion, but the exemplars, he knows specifically why he's writing those documents.
I hear that, and that's all argument that can be made later. But you just said the purpose of it is to show that these are documents that he filled out before. I just don't know why. Yes, maybe someone else testified that he worked at Delta, but I don't know why we can't take the safe path. You still get them in as documents that he filled out prior to, and we take out Delta to satisfy the defense, and there's no appellate issue. You want to take the risk? Why take the risk if it's not necessary?
Judge, I don't believe that there is any risk. We have
All right.
given proper notification as a business record.
It's another get out of jail free card if you're right.
And the only thing I would add, I hear what Your Honor's saying, the only thing that I would add to that is that these records, Karen Nobles couldn't form an opinion on. That's why they went back and did the exemplars.
You can cross her
but
on
I wasn't
that.
going to cross her at all.
Well,
Okay?
wait. Okay, you got my attention there. So she's not. Then what's the relevance of them if she's not going to say that she can formulate an opinion on them?
Judge, it's the state's burden to prove this case. That composition book is critical to our case. It is our belief that he used that book, that he wrote one of the people, the target that he was searching for.
I
So
get
we
that.
have proved that we're going to show that his fingerprints are on it, and then we're going to prove that not only is his fingerprints on it, that we believe that he is the one that actually wrote Omar Bayan and the contents on that page through our handwriting expert. That's part of our case.
No, I hear that. But what Ms. Gowdy has told me is that she couldn't say from these Delta records that that's his handwriting. So there must be some other place. I don't know if it's the exemplars or where, but I suspect she's going to base her opinion, it sounds like, on something other than these records.
That's incorrect. So when
Okay.
she got these records, there were some of the uppercase contained on that record, so it was indeterminate at that time. She wanted lowercase as well, so the exemplars contained lowercase, but some of the uppercase, it's the totality of the circumstances. Going back to that first examination that she did, there were definitely similarities or similar characteristics of some of the uppercase that were found on the Delta application.
So she's going to say that she relied on those records to reach the opinion that the writing in the composition book is Mr. Keetley's.
Yes, as well as the exemplars.
Not is, probably.
Okay, well, but that's all
Probably.
subject. So that's her opinion, probably. But if she's going to say that those records, and I was trying to clean them up to eliminate any other potential appellate arguments, but the state isn't concerned about that, so I'm going to overrule the objection. I'll allow it with the Delta.
Well, I don't understand why they need the page that has his prior work history on it.
Well, I'm only going to allow stuff that she can specifically say that she relied on. So, I mean, that doesn't open the door to a whole bunch of stuff that she didn't rely on. So we're going to narrow it to that.
Judge, she wanted specifically to use the first 2 pages of the application. I don't have any objection to taking out the rest.
Okay.
However, during cross-examination, she's going to be somewhat limited if some of this, because she does look at all of them together. So that's fine. I don't have any objection
Well,
to
let's-
paring it down.
Okay. Let's start with that. If they open the door on cross-examination to additional, you get the opportunity to redirect. And if that opened the door to some of the rest of the application, then absolutely I'll consider it at that time.
All right, thank you.
You're welcome.
The only other thing, Your Honor, is I'm anticipating, based on some buzz that was going on, that Mr. Pruner's going to have this crime scene technician attach that drum to a firearm.
Yes, I wanted to address that. Yes.
Okay, and I've got an objection to that on several bases. The first is, there is no question that that drum and that firearm don't have anything to do with the murders that happened on November 25th, 2010 at 2, 9 to 10 in the morning.
That sounds like your first question on cross-examination after
Well-
they do the demonstration.
Number one, that's it, so it's irrelevant. Number two, at the end of the day, the fact that he can attach it to that drum and how he does it, okay, he's not on trial. And so at the end of the day, he doesn't have any of the physical disabilities that have been testified to repeatedly by their own witnesses in this situation. So number one, whether he can attach a drum to this or not, irrelevant. This is not the gun, this is not the drum. It has nothing to do with this case. It takes completely different ammunition. This is not even a .45 caliber weapon. It's like some other kind of ammunition that's used. That's number one. And number two, it's an inappropriate demonstrative based on whatever this man's experience is, and he clearly doesn't have any physical limitations that we can see.
Okay, I'm at a disadvantage that I don't know exactly how it's going to play out and whether that's exactly what you're going to ask him to do it, or you're going to do it, or why you're going to do it. So go ahead and respond, Mr. Pruner.
The state of Florida's burden is to prove, among other things, the identity of this defendant as the perpetrator of these crimes. Inherent within that burden of proof is to show capability to perform the shooting. If that's a contested issue, whether he was physically capable. You have testimony before you from Norma Jean Towers that she looked at the photographs, she recognized his time, she described it as a Tommy gun kind of thing that he used. And he told her he bought it off the internet. And he wanted to show it to her, and so he had it attached to a rifle, and he, with one arm, fired it. That shows his capability. I'm not suggesting to this jury for any reason that this was the gun that was used. Absolutely not. But it goes to his capability, which is a part of his identity, which is the contested issue in this case.
Okay, well, that testimony is already out there. So if you're going to rely on her testimony for his capability, what's the point of what you're going to do with this witness? I mean, you're not going to use this witness to prove his capability.
No. But to be able to demonstrate that this is the drum magazine for that weapon, whether it be me that does it or the bailiff that does it, just to put it together so that this is the weapon that the jury should have back there so that they can determine its weight, and in corroboration of Miss Towers' testimony, that he was capable of shooting that firearm, a firearm of that weight in the air.
Okay, does it have to be connected in front of them, or can we connect it outside of their presence? It's in evidence. Can we connect it and you just do whatever you want with it, and it can go back there connected?
Well,
instead of a demonstration of connecting it. I don't know the relevance of that.
Because it has to be connected at some
I
point.
just said, can we connect it now?
But it
Then
has
it's connected.
Right. But as a practical matter, you can't load it connected. You have to connect it to the firearm, right? To discharge it. So it has to, ergo, be in a disconnected state to load the drum magazine, and then you connect it to the firearm.
Okay. Well,
So it's implicit that if he shot it, it had to have been connected, right, at the time of shooting.
perhaps there could have been one in a chamber without the.
And that goes to the weight, whether he could or could not do it.
It's already in evidence. That's not the issue. The issue that they've raised is a demonstration where somebody connects it in front of the jury, and that you then are going to be able to insinuate that the ease of doing it, that he could do it, even though that's not the weapon that was involved. That weapon is in evidence. That chamber or circular clip is in evidence. The only issue they're objecting to, I think, is whatever demonstration you're going to do, whether it be the witness, yourself, a bailiff, putting it on the gun in front of the jury. So I'm simply asking, why can't we put it on the gun, and then you show it, you publish it?
Because that's not real life. Because it doesn't come like that. Because you have to be capable of some degree of attaching it. That's just, I mean, it can't be fired without it being attached. It has to be attached. It goes to the weight. Their argument goes to the weight, not the admissibility of the demonstration.
So how do you plan to do this? What are you proposing that you're going to do?
Just attach it.
Who?
Either me, the witness, a bailiff, it doesn't matter to me.
Okay, and then what are you going to do once you attach it?
I'm going to unattach it, disattach it, take it apart, whatever the right word is. It requires the flip of a switch to take it off. It requires nothing to put it on. That's a defense argument for defense purposes, that it doesn't accurately show his capabilities. They have, if they want to be able to argue that they're incapable of it. It's for the jury to decide, to prevent the state from allowing the jury to draw an inference that shows his capability, that shows identity, is to disallow us to carry our burden of proof.
Tell me, the attaching of it by you in front of the jury is to show what? That it attaches to that gun?
How it is done. It is a simple mechanism. It doesn't take a airline mechanic. It doesn't take any. I've shot a gun twice in my life, over 40 years ago. I can do it in 5-10 seconds. Anybody can do it. It's simple, and to release it, you push a button and it comes off. It is not a difficult scenario.
But here's part of their objection. They have a couple of different objections. What is the relevance of it being simple to attach to that gun which that gun has no connection to this case.
Yes, it does, because
Okay.
Norma Jean Towers said he was able to fire it one-handed and demonstrate it after he told her that he bought it off the internet. It goes to his capability. Capability is part of the identification that we have to show.
But does Norma Jean Towers say that she saw him connect it? Does anybody know whether he connected it or whether it was already connected?
It had to be connected when he shot it.
Who connected it? We don't know. If you want to connect it and show it to the jury connected and it go back there connected, that's not a problem. I'm going to allow you to do that. It's in evidence. But to take it, disassemble it and assemble it, we run into relevance where that's not the gun. I mean, you might be able to show, you know, that he can play tic-tac-toe, but that doesn't mean it's not relevant to whether, I hear you about he held it up. There's evidence of that, and it was put together when he held it up. So put it together and show it to the jury. Send it back to the jury. Put together. They're going to be told that they can examine the evidence. So they may go back there and take it apart. But there's just no need for the demonstration, because the only relevance that gun has is Norma Jean's testimony that he held it up and shot it. If she had said she saw him put it together, disassemble it, different ruling. But she saw him hold it up and shoot it. It was together when he held it up and shot it. You can show it to the jury, put together. You can hold it up in front of the jury, put together. That's what I'll let you do. So we put it together outside the presence of the jury.
Yes, sir.
All right. You want to do that now? Do you have?
The weapon, I have not had the weapon introduced or identified yet,
Okay.
so I can't attach it to it before it's in evidence, because that would mislead the jury.
I understand. Is there an objection from the defense after he introduces the weapon to coming over here at the table and attaching it to publish it put together?
I'm not gonna have any objections other than those previously raised.
Okay, I will
To that-
allow you to do that. It's just I don't want you
To that
taking it
firearm.
apart and putting it together in front of the jury. So once you get the gun in, you can come over here to the table and you can attach it at the evidence table, the clerk's table, and then you can turn around and publish it.
I'll just ask for bailiff's assistance at that part, so I'm not even part of that, so it's not even accused that I'm showing the jury in any fashion or blading myself in any fashion to demonstrate. So I'll ask
right.
the assistance of a bailiff with his back turned towards the jury, so there can't be any suggestion of impropriety in attaching the drum to the gun.
Bob, if you'll just come up at that time and you do it with your back to the jury right here, and obviously that is not to become a feature of the trial or a feature of your closing argument or anything like that. All right, are we ready to proceed with this witness?
Yes.
All right, let's bring in the jury. Is the defense ready?
Yes, Your Honor.
Let's bring in the jury. You do it right there on the counter with his back to the jury. Oh, and when we do that, before you waive it connected, is there any objection to me saying that the bailiffs have checked the weapon is just so that the jury's not alarmed? You all right with that, Mr. Pruner?
I'll stand in practice.
Okay, and obviously the defense is all right with that?
That's fine.
All right, the weapon has been checked and cleared by the bailiffs, is what I'll say. Okay, that's not going to interfere at all with the assembly of it. Okay. Yes.
All right, jury entering.
Jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen, jury, welcome back. I know the morning break took a little longer than expected. Please do not hold that against the parties, the attorneys, or anyone else. I take full responsibility for any delays. We are going to get started back where we left off, and I will let you know for planning purposes that we will break about 12:30 for lunch. Mr. Pruder, you may proceed.
Thank you. Mr. Brando, as we broke, you were advising us that it was your recollection that the rifle to which the drum magazine attached, pardon me, was found in a closet within that bedroom, or the room that had been used as a bedroom adjacent to the kitchen.
Yes.
Okay. Showing you what's in evidence of State's Exhibit 126. Is that a photograph of the rifle stored within essentially a closet or cubby within that room?
Yes.
Showing you what's in evidence of State's Exhibit number 130. Was that the photograph taken after the gun was removed there from and placed on the bed?
Yes.
Showing you what's been marked for identification as State's Exhibit number 128A. Do you recognize this exhibit, sir?
Yes.
And is that the a firearm that was shown or retrieved from the bedroom?
Yes.
Judge, I move State's 128A in evidence.
Other than previously discussed?
Other than previously discussed, no objections.
All right, it will be admitted at this time.
Yeah, I may have the assistance of the bailiff.
Yes, yes, Bob, if you'll come forward. And ladies and gentlemen, the weapon has been checked and cleared by the bailiff, just so you know, for safety purposes.
I would ask the bailiff to attach 129A, the drum magazine, to the firearm, Exhibit 128A.
You may publish.
May I have the bailiff's assistance to remove that?
Yes.
So we can keep them separate. I'll just leave them here for this part. Just leave them here for please, sir. Thank you. Were there reward flyers that were found in that same room that was used as a bedroom adjacent to the kitchen?
Yes. Yes.
And did you take a photograph of some of them?
Yes.
Showing you what's in marked for identification 132A, is that a photograph of some of the reward flyers found in that location?
Yes.
Judge of Move States 132A in evidence.
Other than previously discussed, any objection?
No.
It will be admitted at this time.
And there were several documents that consisting of reward flyers and photographs, is that correct?
Yes.
Now, was there an office that was a room that was used as an office in the first floor of that residence?
Yes.
Did you take overall photographs of the office?
Yes.
States 133 and 135, photographs of that office, first floor of the Keetley residence?
Yes.
County Wood States 133 and 135 in evidence.
None other than previously raised.
All right, they'll be admitted at this time.
Okay, Jim, in showing 133, were there computer items including a printer located within that office?
Yes.
Screen over here on the right, a printer in the middle, and another screen on the left, is that correct?
Yes.
And states show you what's already in evidence, it states 134. Another view is we're moving from right to left in that office.
Yes.
And states 135, a photograph now moving from left to right in that office showing a variety of things, including computer items, etc.
Yes.
All right. Now, was there a second floor to this residence, sir?
Yes.
And was there a master bedroom upstairs?
Yes.
May I have a moment, please?
Absolutely.
Showing you 136, 137, 138. Those photographs of the master bedroom, portions of the master bedroom upstairs.
Yes.
One of them states 136, 137, 138 in that.
Other than previously discussed,
None, other than previously discussed.
they will be admitted at this time.
Were there two purple ice cream vans outside the residence, parked behind the residence at the time you were there?
There was.
Showing you states exhibit 144, which is already in evidence. Do you see them at the far right of this photograph, which would be to the rear of the residence?
Yes, sir.
And states 147, 145 already in evidence. These closer views of the vans in 147.
Yes.
May I have a moment, Your Honor?
Absolutely.
Your Honor, I was incorrect. 144 was not previously introduced into evidence, which is the exterior rear. Sorry.
None other than previously discussed.
You want to move it in now?
Yes.
And no other objections than previously discussed?
No.
All right, it'll be admitted.
And does this photograph show the relationship of where the vans were, ice cream vans were parked with the residence?
Yes, sir.
All right. Thank you. Attended the witness, thank you.
Cross-examination?
Thank you, Your Honor. Let's start a little bit where Mr. Pruner left off. I'm gonna have you look, Mr. Brando, at 11A, 11A, B, and C, defense exhibits, and see if you recognize those.
ma'am.
Are those photographs of the van and poster that were on the van when you were there at the house on November 28th?
Yes.
I would move these into evidence, Your Honor.
Is there any objection?
I haven't seen them.
Take a look and let me know if you have any objection.
No objection, thank you.
All right, they will be admitted. I apologize. What were the other defense numbers?
11 and then 11A, B, and C.
All right, they are admitted.
So if we take a look, that's a photograph of the van. Mr. Pruner had just finished asking you about it and shown a picture of where they were in relation to the house, correct?
Correct.
And then if we look at 11A, that's a little bit of a closer up of the section of the van where somebody would do a transaction, correct?
Correct.
And if we go a little bit closer, we can see that there's a reward poster taped there, correct?
Correct.
And then you took a further close-up of that reward poster, correct?
Correct.
And that reward poster describes a robbery that occurred, correct?
Yes.
And it gives a description of the people that committed that crime,
Yes.
correct? And it puts an amount of $5,000 as a reward for any information.
Yes.
And when you were in that bedroom that had the medical bed in it, the
Yes.
one that was near the kitchen
Yes.
area of the house, you recovered what we see depicted in State's Exhibit 132A, correct?
Correct.
And that is similar to what you saw on the van outside, correct?
Similar. Yes.
Now, you recovered, when you executed the search warrant and you participated in that process at this house, you recovered numerous weapons, right?
Yes.
In fact, you went upstairs to the master bedroom, correct?
Correct.
And in the master bedroom, you could see 2 beds in it, right?
Yes.
And there were those kinds of beds that somebody can adjust the back and go back and forth on them. You recall that?
Yes.
And it clearly looked like if it was a male and a female's master bedroom, correct?
Correct.
There were women's clothing in there, men's clothing, correct?
Yes.
And you recovered weapons in there, correct?
Yes.
And you recovered, I want to say it was a shotgun. Do you have your property receipt
I
with
do.
you?
You don't mind if I look at it?
Absolutely. Take a look
Okay.
if you need to refresh your recollection.
Okay. Thank you.
And while you're at it, just look at the items you recovered from the master bedroom.
Okay.
Going back, I'm going to show you State's Exhibit 136. That's the master bedroom, and those are the 2 beds we were just talking about, correct?
Yes, ma'am.
Clearly, they're side by side, and somebody can potentially adjust the backrest of the bed, correct?
Correct.
And those are different from the bed that was downstairs. The bed that was downstairs had railing and was like a medical bed, correct?
Correct.
So when you were searching that room, you recovered firearms, correct?
Yes, ma'am.
What are the firearms? Tell the jury what the firearms are that you recovered from that room.
There was a .22 caliber rifle, a shotgun, a gun box, miscellaneous ammo, and 45 caliber live rounds from a magazine.
Okay. Did you recover a Taurus 45 caliber handgun from there?
Yes.
And the magazine that you're talking about, was it in the handgun or was it separated out from the handgun?
I can't recall.
Do you recall the type of ammunition that was in that magazine or clip?
It was CBC 45 Auto P live rounds.
And those were 45 caliber live rounds, correct?
Yes,
And then I think you told us you recovered a 22 rifle.
ma'am. Yes, ma'am.
Does that look like, I'm not a big gun person either, but does it look like a long gun?
Yes.
And then you recovered a shotgun there,
Yes, ma'am.
correct? You told us that you recovered some, independent of the clip for the Taurus handgun, that you recovered some other 45 caliber ammunition that was in a box, right?
Yes.
And that was in a Winchester box, correct?
Yes.
And you were a crime scene technician for how long?
At that time, it was 7 years.
And in your experience as a crime scene technician, it's not like Winchester ammunition is rare, right?
No, it's not.
It's one of the most prevalent manufacturers of different caliber ammunitions that people can buy for their weapons, correct?
Correct.
Let's talk about the weapons that you recovered from other areas of the house. So we saw the one, this one over here,
Yes, ma'am.
and this one was originally, it was in that closet that we saw in the picture, and that's in the room where the medical bed was, correct?
Correct.
And it was in a closet, and then somebody that was searching took it out and put it on the bed, and you subsequently impounded it,
Yes.
correct? Besides that, what else did you recover from the downstairs area?
Well, if you don't mind, I can read from my notes because it's been a few
Absolutely.
years. But
Go ahead.
basically downstairs, we collected numerous items.
I'm talking about specifically firearms.
Firearms, okay. So, like I said, if I could refer to my notes here,
Sure.
the Glock 45 caliber magazine was found in the kitchen pantry.
Let's talk about that before we move on.
Okay.
Do we have that magazine in here? And this was just kind of randomly sitting in a shelf along with stuff people would keep in their pantries,
Yes.
right? You know, and not to be disparaging in any way, shape, or form to my client or his parents, but the house was cluttered.
Yes.
And so you would find all sorts of stuff in the pantry, not just stuff that normally goes into pantry. This was there, medicine bottles, papers, all sorts of stuff, correct?
Correct.
Inside this clip, what kind of ammunition was there?
There was a Spear 45 auto live rounds. There were 6 of those.
And Spear is a different kind of manufacturer than Winchester, correct?
Yes.
And there were 6 rounds in that clip.
Yes, ma'am.
What other firearms did you find?
We collected a Mossberg 22 caliber rifle from the office. Okay.
The office was that one photograph that was here,
Yes, ma'am.
and it states exhibit 133, correct?
Correct.
So there was a rifle there, it was just kind of leaning up, right?
Yep.
And it was a 22 caliber Mossberg.
Correct.
Is that another long gun like the one upstairs?
Yes.
Okay. And what else did you find?
We found again the 100 round ammo drum on the downstairs bedroom. That had miscellaneous 7.62 rounds in there.
How many?
Miscellaneous. I don't know.
You don't know?
We didn't count.
Okay.
But I put 11. I put miscellaneous 7.62 by 39, which is a type of round it is that came from that drum. There's obviously several. There wasn't just 10 or 12 or whatever easy count, but you know there were several in there. And then from the downstairs bedroom, I found our SD rifle with 2 magazines, which was the rifle, and then a 22 caliber rifle as well from the downstairs bedroom.
All right, so the rifle that you talked about with the magazines is this rifle that's already in evidence. I don't know what number it is. I think it's 128.
Yes, ma'am.
Okay. And then the other rifle was another .22 rifle, correct?
Correct.
And was that a Ruger?
Yes, ma'am.
And in addition to collecting evidence that law enforcement was finding. So your job is they find it, you take a picture, right?
Yes, ma'am.
You take a picture and then you impound it into evidence. You package it, you document it, you take it over to the HCSO evidence room and you turn it in.
Correct.
And in addition to that, did you also try to process areas for fingerprints besides the composition book?
No.
Okay. Did you process anything for blood?
No.
And typically what happens is when you're a crime scene technician and you're assisting law enforcement, if the detective sees something that looks like blood, you take it on either a piece of carpet, on a piece of clothing, on a wall, on a pillow, wherever, and they want you to do something with it, you'll take a picture of it and you will collect that item, correct?
Correct.
And that didn't happen here,
No.
right? Your Honor, if I could have a second?
Absolutely.
You also collected a pair of boots, right?
Yes, ma'am.
And those boots were among other shoes. They weren't the only shoes. They were among other shoes that were like right there when you walk in.
Yes, ma'am.
So when you walk into the house, you walk into this little area, and then you go into kind of the kitchen area,
Yes,
correct?
ma'am.
That's how you walk in. It's not a big house,
No.
right? And so you walk into the kitchen area. We've seen pictures of the kitchen. And then just to the left, I think it is, of the kitchen is where the living room is, right?
Yes, ma'am.
And then you go upstairs and there's a couple of bedrooms upstairs. There's the master and I think either one or two more,
Yes.
correct? And that whole area, that whole entire house was searched, right?
Yes, ma'am.
And so you recovered a pair of boots. I think there's a picture of them, but I don't know how long it'll take me to find them. That was up in that, we'll introduce the Ramirez. It was in that foyer area that we just finished talking about, correct?
Yes, ma'am.
There was nothing on those boots that you thought, I need to swab this and send it over to FDLE for DNA testing.
Right. At the time, we didn't do any examination of the boots at all.
In fact, if we see the photo, and if I don't find it, I'll show it to the jury some other time, but the boots look pretty pristine compared to the shoes that are around them.
Yes.
Do you remember that?
Yes.
Okay. I don't have any other questions.
Redirect.
Mr. Breno, during your work as a crime scene technician, you become familiar with the appearance of blood in its dry and wet forms?
Yes.
At any location in the house, did you observe apparent blood stains?
No.
You read a list of firearms that you observed and retrieved and documented. Was there a Glock 45 pistol that was found?
No.
Thank you.
May this witness be excused by the state and by the defense?
Yes, Your Honor.
Thank you. You may step down. You may be excused as a witness at this time.
Thank you.
I'll ask the state to call your next witness, and we'll go till approximately 12:35, even 12:30, even if we're not finished with the next witness.
calls Karen Nobles.
Karen Nobles. Ms. Nobles, welcome and good morning.
Good morning.
If you'll come forward to be sworn wherever you're comfortable, if you'll face me and raise your right hand, please. Thank you. Do you swear affirm any testimony that you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can put your hand down. If you'll follow the bailiff around to the ramp that leads up to the witness chair, please watch your step. When you get to that chair at the end, go ahead, have a seat, make yourself comfortable. That microphone in front of you does adjust. It goes up and down and moves closer if necessary. It looks like you might have some stuff you need to unpack, so go ahead and let me know when you're ready.
I'm ready, sir. Thank you.
All right. Ms. Doherty, you may proceed when you're ready.
Your Honor, this time we'd introduce State's Exhibit 94, Mr. Keetley's employment records.
All right. Anything other than previously discussed?
No, Your Honor.
All right. It'll be admitted at this time.
Please state your name for the record.
Karen Nobles, N-O-B-L-E-S.
Did you formerly work at the Florida Department of Law Enforcement?
I did.
When did you work there?
Between the years of 1989 and 2014.
What was your position there?
I was a forensic document examiner assigned to the documents section in the crime laboratory.
As a forensic document examiner, can you tell the jury what type of training you received in this area to become a forensic document examiner?
Certainly. I did my initial 2-year apprenticeship at the Escambia County Sheriff's Department in Pensacola. During that time, I worked side by side with a forensic document examiner. I was required to read and become familiar with the texts, to study the methodology, to learn how to use the equipment that was in the laboratory, and to do side-by-side comparisons with the examiner for a period of 2 years. I was tested routinely along that process, both orally and written and practical tests.
And prior to coming to Florida Department of Law Enforcement, did you work anywhere else as a forensic document examiner?
No, that's where I got my initial training. I worked after that, but not before.
Have you ever taught or lectured or conducted any seminars in the area of forensic document examination?
Yes, ma'am.
Can you describe a little bit of that work, you teaching the course?
Sure. I have guest lectured at some of the local colleges in the Pensacola area in their forensic science or legal reporting classes. I have taught forensic document classes for attorneys, law enforcement officers, the Institute of Internal Auditors, industrial security, pretty much anybody that has to deal with documents, Big Bend Fraud and Forgery Task Force. I taught a class in some legal acceptance of document evidence to the judges in the First Judicial Circuit, and basically anything to do with documents when those people have to deal with looking at the physical evidence of the documents. I've provided training.
Are you a member of any organizations related to forensic document examination?
Yes, ma'am.
Can you tell us what organizations you're a member of?
Sure. I'm a fellow with the American Academy of Forensic Sciences in their question document section, the Southeastern Association of Forensic Document Examiners, the Scientific Working Group for Forensic Document Examination, and the NIST, which is the National Institute of Standards and Training, has organizations for scientific area committees that are involved in writing and producing standards for the field. I'm a member of that. And finally, the American Society of Question Document Examiners.
The American Society of Question Document Examiners, are there actually criteria that you have to qualify in order to become a member?
Yes.
Can you tell us what the criteria is?
Sure. You have to have a baccalaureate degree as a minimum. You have to have completed at least a 2-year training program. You have to have 2 years experience before you can apply, and then you apply as a provisional member. You spend 2 years in the organization. You have to present a paper during that time, and then you start your testing process, which involves oral, written, and practical testing, which takes another 2 years, and then you are accepted as a full member.
Have you ever been qualified as an expert in a court in the state of Florida in the area of forensic document examination?
Yes, I have.
Approximately how many times?
Probably about 150 times.
What about in any other jurisdictions?
The federal court, the Northern District, and the Southern District, some military courts, and some administrative hearings.
Can you tell the jury what is forensic document examination, what you do?
Sure. Basically, it's looking at any of the physical evidence on the document in order to determine its source or its authenticity. Source, did it come from a particular printer, a particular person, a particular office machine? And authenticity, is it genuine, has it been altered, or has it been manufactured? But is it what it purports to be, or are there changes to it since it was created?
Okay. And one of those things you said, source. Is it a particular writer? Is that part of what you do as a forensic document examiner, take an unknown sample of handwriting and determine possibly who may have written that document?
Yes, ma'am.
What is the basic theory of forensic document examination in regards to identifying the source of a handwriting or handprinting?
The three basic premises we have are that no two people write alike, that everyone has some variation in their handwriting, and that you actually cannot write exactly the same way twice or more than twice to where it would overlay perfectly.
Okay. And are you familiar with when we used to have carbon copies?
Yes.
Like a form in triplicate. And when somebody writes, every one of those forms look exactly the same. Is that correct?
Correct.
So when you're saying that when a person writes, when one person writes, there is some variation, can you explain that to the jury?
Sure. Each of us learns to write basically the same way by looking at a copybook that the teacher's given us or what she's written up on the board. And we try as hard as we can to make the letters look exactly like that. But we each have our own abilities and our own way of making the letters. As we get towards the end of high school, we've developed kind of what they call handwriting maturity. And we have variations from that. We may make some letters taller, some shorter. We may not have two of the cursive letters routinely, but that's variation in writing. So because we're human and we use bones and muscles and it's not a machine, you don't have the ability to write exactly the same way twice. Much the same way that a baseball player can't hit a home run every time he steps up to the plate. There's so many external and internal influences that it's not exactly the same way each time.
When you are trying to identify a writer of an unknown writer of a document, how can you make a determination as to a writer if there are these variation in a person's writing?
Can we approach?
samples, I believe I asked you if there are variations in a person's writing. How is it that you can possibly determine the source of that writing?
So when I look at the questioned or unknown writing, I look for deviations from the copybook style. The person has a habit maybe of crossing a T a certain way, or always making one letter taller or shorter than the letter next to it. And those are the variations that I then look for in the known writing. I have to find each of those variations within the known writing.
And is that sometimes what you refer to as common characteristics?
Yes.
Do you also, as part of your job as a forensic document examiner, can you also potentially eliminate a person or a source of a writing? Say that that is not the person who wrote a document.
Yes.
Is there a standard methodology at the Florida Department of Law Enforcement when you were working there for conducting a forensic document examination in order to potentially determine the source of the writing?
Yes.
Did you follow that methodology in this particular case?
Yes, ma'am.
And is that the same methodology that is followed nationally in crime labs across the country?
Yes.
Is it also consistent with the methodology implied by international crime labs,
Yes.
such as Scotland Yard?
Right.
When you were at the Florida Department of Law Enforcement as a forensic document examiner, were you given proficiency testing?
Yes, twice a year.
And was that for every year that you worked at FDLE?
Yes, ma'am.
And how many years did you work at FDLE?
From 1989 till 2014, so that would be 25 years.
Part of that proficiency testing, were you actually given documents of handwriting or handprinting where their writers were known and asked to determine whether or not you could actually identify the source of that writing?
Yes, the samples came from an external agency, not from within our own agency.
And in that particular testing, the source of those writings were known ahead of time, is that correct?
Yes.
And you, by comparing the unknown source to a known source, you were able to correctly identify and match it to that source, is that correct?
Sustain that. Don't lead the witness. Rephrase.
Tell us about the proficiency testing as it relates to whether or not you can identify a known source to an unknown source of the writer, and if you were able to do that correctly.
I did get the correct answers in each of the tests. Sometimes they were eliminations and sometimes they were identifications, and there were often sometimes no conclusions depending on the type of writing that was provided.
Did you ever fail any of those proficiency tests at Florida Department of Law Enforcement for all the years that you worked there?
No.
So you were able to guess correctly as to whether or not that was the source of a known writing, is that correct?
Yes, doing the side-by-side comparison of the characteristics provided the correct answer.
And you said at some point you were also given tests where you had to, that were not the same writer, is that correct?
I'm going to overrule that one, but be careful not to lead the witness.
Let me rephrase, Judge. You had mentioned elimination, is that correct?
Yes.
Tell the jury what you mean by you were able to eliminate the source of a writing.
So the characteristics are not in common. There are significant or structural differences in the writing. An O going in opposite direction or just no characteristics in common. Oftentimes in the test, in order to be tricky, they will have somebody fill out one portion of the document and somebody fill out another portion, because if you were not paying careful attention, you might look at the first half and say, yeah, that's the writer, and miss the fact that there was other writings within that.
Did you ever fail any of those proficiency tests involving eliminating potential writers or writers that did not write the same document?
No.
Does the Florida Department of Law Enforcement assign a unique case number to every case that is worked by the Florida Department of Law Enforcement?
Yes.
And did you specifically work on Florida Department Law Enforcement case number 2010-003-08433?
Yes, I did.
And is that the case involving the handwriting samples of Michael Keetley?
Yes, ma'am.
When did you work on that case?
In 2013 and 2014.
Based upon your work on that case, did you author 2 reports?
Yes.
And were both of those reports, were they based on two different submissions from the Hillsborough County Sheriff's Office?
Yes.
I want to ask you about your first submission, or the Hillsborough County Sheriff's Office first submission. Were you provided with a question document to determine whether or not you may potentially be able to identify who was the writer of that document?
Yes.
And I'm going to show you what's been already put into evidence, states exhibit number 15, which is a composition book. Do you yourself, when you examine an item, put that unique FDLE case number so you can later identify it as one of the items that you actually examined?
Yes.
And do you recognize the markings on that particular item?
Yes.
And were there, along with that item in states exhibit number 15, were there two pages that were photographed or photocopied that were of particular note in this case in order for you to determine who was the potential writer of those two pages?
Yes.
And are those the two pages that are also contained in that exhibit?
Yes, ma'am.
And there is a monitor to your right, I believe. Sorry, to your left. My right. Was this one of the pages that you were asked to identify if you could possibly determine who wrote that particular page?
Yes.
Then I'm going to show you this page. Was this the other page in states exhibit number 115 that you were asked to determine whether or not you could possibly tell who wrote that particular page?
Yes.
Part of that first submission, when you received that item, did you also receive some documents that were the purported handwriting of Michael Keetley?
Yes.
Were there two submissions that were sent to you, one containing 19 pages that contained handwriting on it?
During that first submission?
Yes, ma'am.
Yes.
And did you also receive a 22-page machine copied of documents that contain the purported handwriting of Michael Keetley?
Yes, ma'am.
And did some of those include his employment records?
Yes.
I'm going to show you what's already been introduced into evidence, states exhibit number 94. Were these part of the original submission to you of Mr. Keetley's employment records?
Yes.
And I've just showed you 2 pages, is that correct?
Yes, ma'am.
You received more pages than that, is that correct?
Yes.
And when you were comparing the normal course of business records, did they actually contain some handwriting, some hand printing on those documents?
Yes.
And did you do a side-by-side comparison looking for some of those unique characteristics in order to determine whether or not you could make any conclusions as to whether or not Michael Keetley, from those known source documents, was the writer of of those 2 pages from the composition book?
Objection. Can we approach?
Yes.
Nobles, based on the submissions thus far that you had received in the first submission of the State's Exhibit 115, the composition notebook, and those 2 pages that you were asked to review, as well as the other documents, the employment records that contain handwriting, did you do a side-by-side comparison of those items?
Yes.
And based on that information, were you able to draw any conclusions as to who was the known writer of State's Exhibit 115?
Yes.
Containing this photo? And what was your opinion? What were your conclusions?
I said there were indications that the writer of the known writing submitted to me was the author of the first page that you showed, and that there was no conclusion regarding the second page due to some limitations in the evidence.
And you said that there were some indications. That's as much as you could say at that point. Is that correct?
Yes.
Can you tell us why it is that why you could only arrive at that conclusion? What were some of the limitations?
The biggest limitation at that point was that the known writing did not have lowercase hand-printed letters in it. So I didn't have that to compare. You have to compare A to A, B to B, same style of writing. The other limitations was that the known writing was not, had been photocopied or scanned at a poor quality. So some of the characteristics I was not able to see.
So there was some kind of distortion in the copy, is that correct?
Yes.
Okay. But you said that there were some indications. Were there some uppercase letters that you noticed that had similar characteristics that you had seen on that first page of State's Exhibit 115?
Yes.
Based on those limitations, did you have contact with the state attorney's office to request that some handwriting exemplars be done in this particular case?
Yes.
Can you tell the jury what are handwriting exemplars?
Sure, those are writings where the person has been asked to sit down and write specific word and letter combinations, and sometimes even in a specific style, in this case, hand printing.
Okay. And were directions given to Hillsborough County Sheriff's Office or the detective who would be collecting those exemplars as to what was needed or what was required in order for you to make your determination?
The FDLE provides a general sample packet that has a handwriting questionnaire, a warm-up sheet, and then directions saying, you know, please have the person sit down and write words and letters, the questioned items, dictate those words to them and have them write those words a number of times.
I'm going to show you State's Exhibit 188C. This is already in evidence. 188C. Is this the Florida Department of Law Enforcement handwriting questionnaire that is requested for law enforcement to fill out and go over with the potential writer that you're trying to identify?
We actually asked that the subject of the handwriting exam fill that out.
Okay, so he is the one that is filling it out, is that correct?
If it's done correctly, yes, ma'am.
Okay. And then this is, can you tell us what this is?
That's just a handwriting warm-up sheet. Whenever somebody sits down to write upon request, they're generally not relaxed, and so this kind of helps them kind of get relaxed and not focus so much on how they make each letter, but to just kind of get warmed up with the muscles and everything. And it's just made up names that has all the letters in it.
Okay. And this was one of the items that you received after it was done and completed and sent back to you by the Hillsborough County Sheriff's Office, is that correct?
Yes, ma'am.
And on each of these documents that you look at the bottom, is that again the unique FDLE case number as well as markings showing that you are the one who actually examined this particular item?
Correct.
And do you do that for each and every page that was submitted, including the warm-up sheet and the questionnaire and the exemplars themselves?
Yes.
Okay. And I'm going to show you, I'm going to start with the first page of the exemplars. Again, at the bottom, there are, again, the unique case number as well as your markings, and you numbered each page, is that correct? So that you could go back later and refer to where you saw similar characteristics, is that correct?
Correct.
After you had received those exemplars, did you also receive a letter that was the purported handwriting of the defendant?
Yes.
And was that in the same submission when you received the exemplar and the handwriting questionnaire?
It was a following submission.
And did you take a look at those items as well as what you had previously received, and again try to determine who was the source of the composition book 118?
Yes.
Okay. And after you had reviewed all those items, and let's start with that one page of 115 that at the top reads, "By on 507 Ocean Mist." Were you able to draw any conclusions as to, after receiving those known documents containing the handwriting of Michael Keetley and the handwriting exemplars of Michael Keetley, whether or not he was the potential writer of the handwriting on this State's Exhibit 115?
Yes.
And what was your conclusion?
I was able to conclude that the writer of the known writing provided to me probably wrote the questioned writing on the page showing on the monitor right now.
Okay. And what was the basis of your opinion that he was probably the person who wrote this document, this page?
That there were quite a few characteristics in common, individual characteristics that appeared both in the known and the question, as well as the combination of those characteristics. And I have had no fundamental differences or structural differences within the handwriting.
And what about the second page that you looked at, that handwriting?
I was able to also say that that was probably written by the writer of the known writings.
Okay. And was that, again, can you tell us what was the basis of your conclusion for that particular page of State's One Exhibit of 115, State's Exhibit 115?
Pretty much the same, that the characteristics are in common with no significant differences. The writing speed, the writing quality, the height relationships, baseline alignments, letter formations, eye dots, anything along that line. I had enough in common to support a conclusion of probably did write.
Okay. And so you are not saying that he is definitively the writer of this item, is that correct?
Correct.
Okay. And going to your conclusion that he probably did write, did you keep notes on what some of the similarities were, what some of the common characteristics from this particular handwriting in State's Exhibit 115 to those other sources you have testified that you received and reviewed?
Yes.
Okay. Can you step down? I'm going to ask you to step down to the podium. Can you show the jury just a few examples of some of the similarities and the common characteristics between, and I'm going to use that first page saying "by on State's Exhibit 115. And you can put your notebook right here if you need to. I'm going to start off with showing you or handing you State's Exhibit number 94, the first two pages of his employment records. Were there some common characteristics that you noted on State's Exhibit 94 that you found on that page for by on the common characteristics of some of the handwriting?
Yes. So do you want me to just point to?
Yes.
Okay.
Absolutely.
So if you look at the shape of the uppercase B in bylon or bylon, there's a very small top portion and a very wide bottom portion. Bear with me a minute while I locate it. may be under the redaction. So it's most likely under the redaction.
So this document is somewhat different from the item that you reviewed, is that correct?
Correct. There's been some areas redacted which had handwriting under it. Do you want me to try to find it in another document?
Yes.
Okay.
Is that part of the exemplars?
Yes.
Okay, let me get the exemplar for you. Here are the exemplars. What page?
Was number 3.
I'm going to give you page 3 of states number 188C.
And if you look at the, once again, the word by on here where I'm pointing, you see that it's a very narrow top part of the B and a very wide bottom part of the B.
Okay.
And looking at the letter A, we have a cross stroke that extends all the way across the letter and connects or goes into the next letter.
Do you want states exhibit number 94?
Yes, on States Exhibit number 94, that is present in the word Michael, the AEL area.
Can you do that side by side to that page that is states exhibit
Sure.
115?
So you've got the A coming in Bayon and you've got the A in Michael. The A in Atlanta has a little bit of a crossstroke, not quite as severe coming across.
As when he said his name, is that correct?
Yes.
Okay.
Looking at the lowercase I in Bayon, it's a lowercase I used where almost all uppercase letters are used. There's no I dot over the I, and the I is much smaller than the A and the L on either side of it. And I want the employment.
States exhibit number 94.
Yes, ma'am. And the small lowercase I, the shorter one, as well as no I dot, is visible in the word mechanic and also in the word line. The uppercase L in Bayon has a curved bottom. And that characteristic I found in, once again, States Exhibit 94.
94.
If you look at the L in the word line up here, you'll see the curved bottom or base stroke curves up. The lowercase o in Bayon, once again, is much smaller or shorter than the other letters within that word. Also in States Exhibit 94, in the word production here, where you see the R, then the very short O, and then the uppercase D, which is taller again. And then the uppercase N, which has a much, has a shorter right side than left and also angles out to the right. And once again in States
94.
Exhibit 94. And see the word none. Once again, the left is longer than the right side, and it angles off to the right. And these are not the only instances of those letters within the known writing. I've just chosen a few to demonstrate kind of how we do what we do, because it's a very slow, long, boring process.
And I just asked you for a few visuals so the jury could see. You said that those weren't the only examples of those characteristics that you found in the exemplars as well as the other known items. Is that correct?
Correct.
Okay. Can we also go to Ocean and just do a couple more examples of similar characteristics that you found in the exemplars as well as the known source documents of Michael Keetley?
Sure. The O in Ocean is open at the top, and I found that in the exemplars,
States Exhibit 188C.
page number 32.
Page 32.
See. Make sure I'm putting everything on there. The lowercase o in Bylon, it's probably difficult to see, but it is open at the top. The C in Ocean is a very narrow C. In other words, it's taller than it is wider. And that would be number 53 of States Exhibit 88C. Is that correct? What States Exhibit?
188C. And what page number?
The next one, 33. In the word Mexico, right here, we've got the C that's very tall and narrow rather than shorter or even rounder. The lowercase e in Ocean, the top bulb of the E, which is normally about halfway down the curve, is very small and almost closed. And I found that characteristic on page 31 of the exemplars.
Okay. Again, States Exhibit number 188C.
In the word friends, right here.
Okay.
The lowercase a in Ocean has a little bit of an opening once again up at the top on the right, and I found that on page 32 of the exemplars. Right down here in the word MySpace.
Okay. Is there also MySpace that's written on our particular document? Could you hold those side by side
Yes.
and point to where the MySpace is written?
We've got the one here on the question writing and here on the known writing.
And again, these were just some of the examples of common characteristic for that particular C. Did you find that characteristic in some of his other documents that you looked at?
Yes, ma'am.
Okay. And then let's go on to the A.
That was the A.
Okay.
And then the N is an uppercase N, even though the other letters are lowercase. And that would be in page 11 of the exemplars. I don't think I have that one noted correctly. Let me see, page 23.
There you go.
Thank you. Yes. So we've got the N, which has a little tick mark going off to the right on the right-hand side of the staff. And in the word Jimenez or Jimenez, there's also a tick mark going off to the right-hand side.
Okay. And were there other documents with his that were known, the purported handwriting of Michael Keetley, where you saw again that end with the little tick mark at the end?
That was, I think that was the only one I saw of that one.
Of
That
that
was
particular.
a characteristic that didn't happen very often.
Okay. Can you go ahead and have a seat?
Sure.
Now, I asked you just to show the jury a couple of the similarities or the common characteristics that you looked at. Was that the total of the characteristics that you were able to determine?
No,
Okay, and you said that this was a very, that you spent a lot of time, is that correct, looking at States Exhibit 115, those 2 pages, as well as all those other sources of handwriting, is that correct?
correct.
Can you, if you can you approximate for us how many of those common characteristics did you find and were able to link back to States Exhibit 115, that composition notebook?
Looks like I have probably between 35 and 40.
Were there any concerns looking at that document as well as the known handwriting, the known purported handwriting of the defendant, where you were concerned with eliminating him as a potential source of the writer for States Composition Book 1, States Exhibit 115?
I'm not sure I understand what you're asking.
If you had, part of your job when you're looking at States Exhibit 115, would you also be able to draw a conclusion that he was not could you have eliminated him as the source if you found that there were not enough similarities in the common characteristics?
There would also have to be some significant differences in order to eliminate him.
And you did not do that in this particular case, is that correct?
Correct.
And what was your conclusion as to States Exhibit 115 for both of those 2 pages that you looked at?
That the writer of the known writing submitted to me was probably the writer of the questioned entries in the notebook.
Your Honor, may I have one moment? All right, this time we pass the witness.
All right. Let me have the attorney's approach briefly. Gowdy?
Your Honor, I don't have anything to ask.
All right. May this witness be excused by the state
Yes, Your Honor.
and by the defense?
Yes, Your Honor.
Thank you. You may step down. You may be excused as a witness at this time.
Thank you.
Ladies and gentlemen of the jury, it is perfect time for lunch. We are going to, it is 12:30. So an hour will bring you back at 1:30. Let's do 1:45. I'll give you an hour and 15 minutes. Please do not discuss the case amongst yourself or with anyone else. Please do not do any research related to the case. And also, please avoid any contact or reports of the case outside of the courtroom. All rise for the jury. jury has exited. Everyone may be seated. I gave them an hour and 15. I considered giving them more because I know you all have some work to do on trying to agree as much as possible to some redactions and then get those redactions done. But if there's any disagreement, I need to hear it and rule.
Your Honor, I did during Ms. Noble's testimony, and not before Ms. Noble's testimony, provide Mr. Pruner with my requests for redactions as well as some case law. I do have a copy of both for the court as well.
Okay, well, do you mind at least initially discussing it now, and if there's anything I need to go and research, I can do that?
Having read it in the last 15 minutes, having not had the opportunity to research anything, I'm not prepared to do this.
Okay, I'm not forcing you, just
and-
asking.
No, I get that.
Just a
Thank you.
request.
I appreciate that, Your Honor. Where I'm at is there's no way that we would be able to get these redactions done because I'm going to have some disagreements on a few of them, at least, in time to put Mr. Detective Schramm on this afternoon. So what I suggest, and we're going to fill up most of the afternoon, but we may not fill up till 6.
Okay.
Is at the end of the day we address this, and I can have the redactions start tomorrow morning.
I'm comfortable with that, if that's better, and then we can discuss it at the end of the day. I make my decisions on those issues that are still in dispute, and then you can make the redactions overnight, and we'll start with that witness in the morning.
I don't think there will be a lot of items of dispute. There is one thing that I want to bring up. There was an area that I had not redacted before because, well, anyway, there's an area where he says, the detective says, I know you haven't been arrested before. So I'm going to be suggesting that should be redacted in light of the surrounding redactions that counsel wants.
And I believe, if I'm not mistaken, and correct me if I'm wrong, that was already, a portion of that was redacted. You're just saying it needed to be backed up a little bit more.
No, it's within some proposed redactions. It's left unredacted within some proposed redactions. Of the
You're all right with that?
Yes, Judge.
Okay.
And Judge, understanding that we're going to try to limit what the court may have to
Right.
discuss, I do want to give you the cases in case you
Sure.
or your staff attorney want to look at them ahead of time.
Sure, absolutely. I have nothing else to do during lunch. I'll start looking at these. You all keep working together and narrow it as much as you can, and then I'm happy at the end of the day to rule on whatever's left, make the redactions overnight, and we're good to go with that witness tomorrow.
Yes, well, the redactions will just be done in the morning.
That's what I meant. That's
My
what I meant.
staff, I can't ask. Anyway.
Not a problem.
Yes.
All right, have a nice lunch.
Thank you.
My recollection is that we finished with Karen Nobles, so we're on the state's next witness when we bring the jury in. State ready for another witness?
Yes.
Defense ready? Mr. Keetley is present and situated. So is the jury ready?
Yes.
Let's get them. Who is going to be your next witness?
Mr. Cantu.
Cantu? Richard? What's
What number is Alex?
100? Okay, no problem. Yeah, that was. It's like every day I get an email and he dropped 10. Like 10 at a time. I guess they only send an email if it's 10.
Well, the choice came out for Hillsborough County yesterday or the day before, so I guess a lot of people are accepting, like if they have IB, and so they. I got the email like Nina got into the IB program in Hillsborough, which I had applied for, but I don't know.
See, we're considering it now. We didn't apply the first time, but we're going to apply the second time. The deadline's coming up.
And she tells me Alex is so smart.
Oh, really?
Yeah. If you ask me, I think she has a little crush on him, but she doesn't. She's like, Mommy, why do you say that? I said, because you talk about him all the time.
He's such a nerd. He's so socially awkward.
That's okay. They'll come out.
Terrible.
He does better as he's around me.
I'm surprised he has any. He says he has friends in school, but I'm surprised.
You know how they act different when they're in school than when they're home. My son is sexually awkward. He was in school. He was like, came in a hill. No. He's the white one's better when he does work.
Well, he's confident he's going to get into.
Oh, it's fun. Well, to tell you the truth, I was wanting to go to the top, and I said, even though Asha was registered yet,
Right.
so I'm like, until it's
Well,
registered,
not sure
I
there's a
can't. I'm not taking her.
So that's another way. So, just afraid that if you get like 40 going, it's just going to be like hitting a brick wall. Because that everybody. But I'm hoping, and you just don't do that conversation, post and stuff. It ultimately may. They're not going to make a decision now. But they want, if you can expand the contract, that's what I hope it is close enough. Yeah.
Ready, Judge?
Yes.
All right. Jury entry.
Jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, welcome back. Good afternoon. Did everyone have a nice lunch? Well, you all certainly look and sound happy and refreshed. So we are glad that you came back, and we are going to pick up where we left off. It is time for the state to call their next witness.
Richard Cantu.
Richard Cantu. Mr. Cantu, good afternoon and welcome. If you'll raise your right hand for me, that's fine. That's good enough. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. You can, if you please follow the bailiff, please watch your step. There's some cords. They're taped down, but
Okay.
watch your step. And then there's a ramp that has an incline. When you get to that chair, go ahead and have a seat. That microphone is adjustable, so it comes forward and up and down.
Okay.
All right. You may proceed.
Thank you. Good afternoon, sir. What is your name?
Richard Cantu,
Mr. Cantu, how old are you, sir?
40.
Mr. Cantu, do you recall where you were on Thanksgiving night of 2010?
No.
Do you recall anything involving the circumstances surrounding the deaths of Sergio and Juan Guitron?
No.
Do you recall whether you knew them or not?
Yeah, my cousins.
Do you know Gonzalo Guevara?
My cousins. Friends.
Do you know the Lucas family?
No.
Do you know Ramon Galan?
Yes, my cousin.
Do you have any memory of being with your cousins Juan Guitron, Ramon Galan, and Sergio, thank you, Sergio Guitron on Thanksgiving night?
No.
Sir, do you have any type of physical problems or disabilities?
Yes.
What are those?
My legs and my arm.
Do you know what caused those?
Yes.
What?
45.
Were you shot in the head?
Yeah.
Do you have any memory of how that occurred?
No.
Do you have any memory of who did that?
No.
Are you working?
No.
Are you able to work? No?
No.
Are you able to use your right arm?
No.
I have a moment, please.
Yes.
Thank you, sir. I have nothing further. Thank you.
Cross-examination.
1 second, please.
Hold on.
Oh.
Cross-examination. All right. May this witness be excused by the state
Yes, sir.
and by the defense?
Yes, sir.
All right. Thank you, sir. You may step down.
Thank you.
You may be excused as a witness. Now I'll ask the state to call your next witness.
Angela Logan.
Angela Logan. Ms. Logan, good afternoon and welcome.
Thank you.
If you'll come forward wherever you're comfortable, if you'll face me and raise your right hand to be sworn as a witness. Thank you. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you. If you'll follow the bailiff around to the ramp that leads up to the witness chair, please watch your step. When you get to that chair, go ahead, have a seat, make yourself comfortable. That microphone in front of you does adjust. It goes up and down, and it moves closer if necessary.
Okay.
All right, you may proceed.
Please state your name.
Angela Logan?
Do you live in Hillsborough County?
Yes, sir.
In what part of Hillsborough County?
Riverview?
How long have you been living in Hillsborough County?
Since this time around, since 1996.
Do you know a person by the name of David Beckwith?
Yes, I do.
And how is it that you know him?
He's my ex-husband.
When were you married to him?
We got married in 2000 and we were divorced in 2009.
At some point on or close to Thanksgiving Day, November 25th of 2010, did you learn from whatever source, media or otherwise, of a murder that occurred of the Guitron brothers on Ocean Miss Court?
Yes, I did.
So I'd like to ask you about the day before Thanksgiving, that being Wednesday, November 24th of 2010. Did you have family that lived, where were you living at that time?
In Riverview. I lived next door to my mother and stepfather.
And on that evening before Thanksgiving Day, did your mother and stepfather have a family function of some sort?
Not so much a function is that my stepfather smokes a turkey every year for Thanksgiving, and we have to start it the night before. Sometimes, you know, a couple friends come over and they hang out. We hang out. We'll build like a little fire in the backyard, and because he has to keep an eye on the turkey, so we kind of keep him company.
Does it become kind of a social event?
Yes.
Okay. Do you recall whether had you already been divorced from David Beckwith by that Thanksgiving Day of November 25th of 2010?
Yes. Earlier in 2010, we started getting along and hanging out with each other. And
okay. So, on the evening of November 24th, going into the early hours of November 25th, did you see David Beckwith?
yes, he was with me and my family.
And that was at what location?
The address?
Oh, no.
Oh, in Riverview, sorry.
It was at your mother and stepfather's home.
Yes, we live next door. The backyards are fenced in together, so between the two homes.
Did Mr. Beckwith leave for any period of time on the evening of or the early morning hours of the evening of the 24th going into the early morning hours of the 25th of November 2010?
No, I didn't.
Was he present the next morning?
Yes, he was.
And the next morning meaning
Thanksgiving morning?
daylight hours of
Yes.
Thanksgiving? Okay. Do you recall how late you stayed up that night?
Not exactly, but probably 2:30, somewhere around in there.
And was Mr. Beckwith present at that location at whatever time you went to sleep?
Yes.
Thank you. No further questions.
Thank you.
Cross-examination.
I don't have any questions.
May this witness be excused by the state
Yes.
and by the defense?
Yes.
Thank you, ma'am. You may step down. You may be excused as a witness at this time.
Thank you.
You're welcome. And I'll ask the state to call your next witness.
Mr. Sackman?
What is the last name?
Sackman?
Sackman? Mr. Sackman, good afternoon and welcome. If you'll come forward to be sworn, wherever you're comfortable, if you'll face me and raise your right hand, please. Thank you. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right, thank you. If you'll follow the bailiff around to the ramp, please watch your step. When you get to that chair, go ahead, have a seat, make yourself comfortable. That microphone does adjust. Absolutely.
Good afternoon, sir. Could you please state your full name and spell your last name for the record?
Chuck Boyd Sackman, S-A-C-K-M-A-N.
And sir, are you employed or are you currently retired?
I've been retired for approximately 2.5 years.
And from where did you retire?
Hillsborough County Sheriff's Office.
What capacity did you work for the Hillsborough County Sheriff's Department before you retired?
I was a crime scene detective.
And how long had you been a crime scene detective with the Hillsborough County Sheriff's Office before you retired?
Approximately 28 years.
In your capacity as a crime scene detective with the Hillsborough County, so would it be safe to assume that you were working for the Hillsborough County Sheriff's Department as a crime scene detective in 2010 and specifically Thanksgiving time of 2010?
Yes, ma'am.
In your capacity as a crime scene investigator and as a crime scene detective, did you participate in the investigation that resulted in the arrest of Michael Keetley for murder?
Yes, ma'am.
And specifically on November the 28th of 2010, did you respond to 4935 Bonita Drive, Mr. Keetley's and his parents' home, to assist in the execution of a search warrant at that address?
Yes, ma'am.
Do you remember more or less at what time of the day or night that you arrived?
I'm thinking approximately 11:20 or so in the morning.
In the morning?
Yes, ma'am.
Now, as a crime scene detective, what is your function when you go out to a scene to assist in the execution of a search warrant?
Predominantly with this particular case, my objective was to assist in the search of certain items, document through photography those items, and collect them.
When you were participating in the processing or the search of the Bonita Drive area, were you working inside or outside of a home?
I was on the outside of the house.
Were there any other members of the crime scene unit also assisting in the search warrant execution?
I believe there were on the inside of the house, but the outside of the house, I basically covered it.
And were you working in connection with and under the direction of the homicide detectives during the execution of the search warrant?
Yes, ma'am.
Can you briefly, well, let me show you State's Exhibit number 190A and ask you if you can recognize what we are seeing in 190A.
Yes, ma'am.
And what is it that we're seeing in 190A?
It is the address that I responded to.
And this would be Bonita Drive, as has already been established through prior testimony, and this is the long driveway leading to the Keetley home. Is that your understanding?
Yes, ma'am.
And what was it that you did when you when you got to that scene?
Basically, all the detectives got together and we proceeded, after reading of the search warrant, we proceeded to search the property.
In what area of the property did you start the search, sir? Did you yourself?
Basically, it was north of the house.
Okay.
We worked in a counterclockwise direction, working our way towards the small pasture area that's to the west of the house. Then we went to the back and then up through the east.
So this is the area, right, and I'm, for purposes of the written record, I'm circling the area, on the top center of the photograph, is that correct?
Correct. You were going in the correct direction also.
Okay, so this is, you come up here and then you started searching in this area right here.
Yes, ma'am.
When you were searching the area, do you see several cars and trailers in the property?
Yes, ma'am, but my primary objective was photographing those vehicles and that. We had other detectives searching the area and they'd bring things to my attention.
All right, so when I meant, so you did see, either because you saw them yourself or they were brought up to your attention, several vehicles in that area that we discussed a few minutes earlier?
Yes, ma'am.
Let me show you what is already in evidence as States Exhibit 189A, 189B, and 189C. This being 189A. Is that one of the vehicles that you photographed in that property?
Yes, ma'am.
And where was that vehicle located?
That was just to the northwest part of the house, if I'm not mistaken.
And 189B? Let me take one. This. That's as small as it goes. 189B is showing what?
It's the interior of that truck.
And 189C is showing us?
It's the back seat area of that truck.
Okay, let me show you States Exhibit marked for identification as 143A, 143B, and 143C. Do you recognize those photographs, sir?
Yes, ma'am.
And are those photographs of 3 additional vehicles that you photographed at the Bonita Drive address?
Yes, ma'am.
And are they in the same, do they fairly and accurately represent the items as you photographed them on November the 28th?
Yes, ma'am.
Judge, at this time I'll move 143A, B, and C in evidence.
Any objection?
None other than previously raised.
All right, they'll be admitted at this time.
Okay, and 143A is showing us what?
It's a Dodge pickup truck. I believe it was just to the west of the house.
Okay, and 143B is showing us what?
It's another vehicle, Chevy pickup, at the rear of the house, if I'm not mistaken.
All right, and if we are looking at States Exhibit number 143A, on the very top of the photograph, do you see what appears to be the back of a blue pickup truck?
Yes, ma'am.
And is that the same pickup truck that we're seeing in 143B?
Yes, ma'am, I believe so.
And 143C, is this another vehicle that you photographed at the same location?
Yes, ma'am, I believe it's one of the Jaguars that was on the property.
I'm sorry, one of the,
Jaguars.
all right. And for purposes of perspective, is the blue pickup truck that we see here the same one that we saw on the prior photograph?
Yes, ma'am.
And going back to States Exhibit number 143B, is this part of the house? Is
Yes,
that the
ma'am.
photograph?
Yes, ma'am, that's the back of the house.
And this is one of those sheds so that you can park vehicles and trailers in there?
Yes, ma'am.
Did you also did you also see some ice cream trucks?
Yes, ma'am, there were 2 ice cream vans.
And did you photograph them as well?
Yes, ma'am.
Did you have an opportunity to photograph and look at a purple ice cream truck? Oh. This one's in evidence already. With a tag 192 XKP.
Yes, ma'am.
And did you also have an opportunity to photograph the inside of that ice cream truck?
Yes, ma'am.
But let me ask you to look at these and see if you recognize them as the photographs of that ice cream truck that you took on November the 28th, 2010. Do you recognize them?
Yes, ma'am, I do.
And are they a fair and accurate depiction of what that pickup truck looked like on November the 28th?
Yes, ma'am, but it's a van, if I'm not mistaken.
And I said pickup truck, didn't I?
Yes, ma'am.
The ice cream truck, the ice cream van.
Yes,
All
ma'am.
right. Judge, 147 is already in evidence. The state will be moving 148, 148A, 148B, and 149 in evidence.
Any objection?
None
Okay.
other than previously
Okay.
raised.
All right, they will be admitted this time.
So 147 shows well, actually, this photograph, is that showing both ice cream trucks?
Yes, ma'am.
All right. And the one that is closest to us with tag 192 XKP is in the front area.
Well, they're both behind the house.
Oh, well, I mean, the front area, I mean, the main area of the photograph.
Oh, yes.
And this area back here, that is the back of the house?
Yes, ma'am.
148, what are we seeing here?
This is the driver's cab area of the ice cream van. It's a Ford Econoline, if I'm not mistaken.
And 148A?
This is the front cab area from the passenger side.
$149.
It's the dashboard area of the Ford Econoline van.
And in the van, we can see sunglasses and a bullet.
Yes, ma'am.
Were those items taken into evidence?
Only the sunglasses. The bullet was left there.
And now 148B, is that the interior of the ice cream van?
Yes, ma'am.
When you and the detectives were searching that area, did you did you notice or did you come in contact with a partial van?
Yes, ma'am.
And where was it that you saw this partial van?
It was to
The same objections as previously raised.
Same ruling now, so overruled. You can proceed.
It was to the east of the house on the other side of the barbed wire fence.
And so let me show you 190C. Do you recognize what we are seeing on this photograph?
Yes, ma'am.
Okay, and what is it that we're seeing in this photograph?
You see the dirt road near the upper third of the thing going from north to south. You then see a clump of trees. Within that area is the house. A little bit to the bottom within that clump of trees is where the upside down Chevy van was.
And is this the area that I'm pointing at?
Yes, within the tree area though.
And is that where you located a partial van?
Yes, it was just the body of the van. All the innards and the front end have been removed.
Let me show you State's Exhibit 150, 151, 152, 153, 154, 55, and 56, and ask you if you recognize those.
Yes, ma'am, I recognize them.
Do they fairly and accurately depict the state of the partial van as you found it and photographed it on November the 28th at the Bonita Drive address?
Yes, ma'am.
Your Honor, 150 is already in evidence. The state will move 151, 52, 53, 54, and 55 in evidence.
Any other objections in previously discussed?
No, Your Honor. No.
They'll be admitted.
When you came upon this upside, this van, how was it on the property? In the upright position, upside down on its side?
It was upside down as you see in the photograph.
When you first came upon the van, did you walk around the van and photograph it in its condition as you were approaching it?
Yes, ma'am.
So let me show you State's Exhibit 150, which has already been seen by the jury and previously admitted. Is this the upside down white van?
Yes, ma'am.
What am I pointing to the right of the photograph?
That's a trailer that's just to the east of the van.
What, if anything, did you notice or attracted your attention to this van, upside down van?
The bullet holes in it.
And are there some bullet holes depicted on this area right here of the van?
Yes, ma'am.
Now, okay, so because of the tag, it's a deadly giveaway, this is the back of the van.
Yes, ma'am.
And what area is this?
That would be the passenger side.
State's Exhibit 151, is this the same van?
Yes, it is.
And what is it that we are seeing here?
It's going to be the driver's side of the vehicle.
Now, to put things in perspective, is this the house?
Yes, it is.
And are we seeing here the, keep on calling them trucks, the ice cream vans that you photographed and we saw previously in the other photographs?
I really can't tell. It's just a glimpse through the trees, but look at one of the other pictures, you see the canopy area where the RV's parked. In that same photograph, and just to the west of that was the vans in question.
And did you notice any bullet holes on this side of the van as well?
Yes, ma'am.
State's Exhibit number 152, which portion of the van are we seeing now?
I believe that's going to be the cargo door, if I'm not mistaken.
And that's the door that opens up?
Yes,
like
the sliding door.
153.
That's going to be the driver's side of the van with the driver's door leaning against it.
And once again, we're seeing the damage from apparent bullet holes.
Yes, ma'am.
154.
This is going to be the passenger side with the sliding glass door next to it.
And what is this area right here?
That's the rear passenger side wheel well.
When you are looking at this truck, did you notice anything on or in the area of the wheel well?
Yes, it was covered with leaves, and there was a projectile within those leaves.
Okay, let me show you State's Exhibit number 155. Okay, and the other one is this the wheel well that we saw in the prior photograph?
Yes, ma'am.
Okay, and at the bottom portion of the photograph, we see a collection of leaves. Is that correct?
Yes, ma'am.
And is the projectile visible from this photograph?
I don't readily see it in this photograph. I took another photograph that's a lot better than that one.
Which is number 156. Okay, so let me put it the other way. And is that a close-up of that same area?
Yes, ma'am.
And is the projectile visible in this photograph?
Say again?
Is the projectile visible in this photograph?
Yes, ma'am. If you would go ahead and turn the photograph where the bullet hole's up at the top of the page.
The bullet hole up here,
Yeah.
which, okay. And where's the,
It's going to be in the center lower third of the photograph right there.
is this, and am I pointing to it on the photograph?
Yes, ma'am.
What did you do when you found the projectile?
I notified all the other detectives. It was, projectile was collected at that time, and the vehicle was hooked up to a wrecker, flatbed wrecker, and towed to our office down on Falkenberg.
All right, so let's go a little bit step by step. The projectile was collected and taken into evidence with you?
Yes, it was.
Evidence by you. It's already been established that the Hillsborough County Sheriff's Office has a specific identifying number for each investigation. And what steps did you take to take this projectile into evidence?
Using gloved hands, I basically picked it up, put it into a small envelope, documented where that projectile came from. It, in fact, then went to a larger envelope that was sealed with evidence tape, had my name, my badge number, case number on it, and data was collected that was sent or turned over to our evidence room for safekeeping.
Let me show you what has been marked as State's Exhibit 163C and ask you if you recognize that. While you're looking, Mr. Sackman, in preparation for this trial, did you have an opportunity to look at these items of evidence earlier?
Yes, ma'am.
Okay. And do you recognize the item that is located in State's Exhibit 163A?
163C.
I mean 163C.
I recognize them, but these are not the ones that came from the wheel well.
That's because I started at the I'm sorry, I handed you the wrong envelope, so. So, hold on to that for a second. So let's start all over again. You took the projectile that you found in the wheel well into evidence.
Yes, I did.
Now let me show you State's Exhibit 156A for identification and ask you if you can recognize that. I apologize, Mr. Sack.
Yes, ma'am. I recognize it.
Okay, and is that the projectile that you recovered from the wheel well?
If I can get a pair of scissors.
No, just from the
From the
markings,
packaging?
From the
Okay.
packaging and the markings?
Yes, it is.
Judge, the state will move 156A in evidence.
Anything other than previously discussed?
No.
It'll be admitted.
Now, the outside envelope does not have your markings, correct?
Correct.
And the inside envelope is the one that shows your identifying information and your markings.
Yes, ma'am.
Now, when this evidence is taken in by you, is it taken to the evidence room?
Yes, ma'am.
And is it stored in a secured location?
Yes, ma'am.
And in order to have access to it, is there a tracking whenever somebody obtains one of these pieces of evidence?
Yes, ma'am. The detective would have to fill out a form, his supervisor would sign it, and then he would take it over to the evidence room and pull the evidence out.
Was this a smaller envelope that you started testifying to earlier before I handed you the wrong envelope, where you put the projectile?
Yes, that's the envelope that the projectile went into.
And does it have your markings on it?
Underneath some of that tape, I'm sure it does.
And does it have the marking, are you familiar with the markings of the Florida Department of Law Enforcement?
A little bit.
And are those markings the ones that you see on State's Exhibit 156A?
Yes, ma'am.
Let me move it here before I. Okay, so you already told us that the decision was made to take the partial van back to your office at the Hillsborough County Sheriff's Office.
Yes, ma'am.
Is it the custom of the Hillsborough County Sheriff's Office that to call a wrecker in order to transport items as large as this?
Yes, ma'am.
And is it the custom of the Hillsborough County Sheriff's Office to have a deputy follow that item of evidence to the office of not the State Attorney's Office, to the office of the Hillsborough County Sheriff's Office?
Yes, ma'am. This is done to maintain the chain of custody.
And once it is taken to your office, do you remember where it was at that time?
We're located at 2416 North Falkenberg Road, our office is. And we have a 4-car garage that we stored it in.
Okay, and is that area secure?
Yes, it is.
And obviously I'm not gonna say that it's is that a controlled area?
Yes, it is.
And you said it has 4 bays?
Yes, ma'am. We have 4 bays.
And did you in fact go back to your office at Falkenberg Road in order to continue examining this evidence?
Not at that time. We processed the vehicle the following day.
And when you processed the vehicle the next day, did you, as you did before, walk around the vehicle to ensure that it was in the same condition as it was when you had last seen it at the property?
Yes, we photographed the exterior and then started to remove some of the projectiles.
And was the exterior in the same condition as it had been before it got transported?
Yes, ma'am.
What do you mean when you say that you started processing the van?
We photographed the vehicle, then we went ahead and started cutting out pieces of the door, the body, and that to retrieve any projectiles.
Let me show you States Exhibit 157, 158, 159, and 159B and ask you if you can identify them. Do you recognize those?
Yes, ma'am, I do.
And do they adequately and fairly depict the portions of the van as they're shown in this photograph and as they were photographed by you on November the 29th when you were searching the partial van?
Yes, ma'am.
Judge, at this time, the state will move in evidence 159, 159B, 158 and 157.
Any objection other than previously discussed?
No, Your Honor.
They will be admitted at this time.
Thank you, sir. And what was the purpose of dismantling the van?
And we retrieved projectiles from it.
$157 is showing you what?
That's showing the exterior of the driver's door.
And 158?
That is showing the interior of the driver's door.
And in order to recover what might have been lodged between these two pieces of the van, was this red portion removed?
Yes, the panel was removed.
And did you in fact recover any projectiles from that area?
Yes, ma'am, we did.
Let me show you State's Exhibit number 59 and ask you if you can tell us what this is.
It's the interior of the door with the panel removed. You see at least one projectile, maybe a few pieces of a projectile.
And is this the area where the projectile and the pieces of the projectiles were located?
Yes, ma'am.
And once you removed them, did you take a close-up photograph of the projectile and the fragments in order to better view what it was that you had recovered?
Yes, ma'am.
And showing you State's Exhibit 159B, what is it that we're seeing?
We're seeing at least one projectile, 5 pieces of projectile, and in the middle on the bottom row is some unknown type of metal.
Okay, let me show you what has been marked for identification as Exhibit 159A. Although the outside envelope does not, does the outside envelope reflect your markings? Does the outside envelope reflect your markings?
The outside envelope is from the Florida Department, and actually it's from
Repackaging?
Detective Tom Pettis, but the inside envelope is the one I created.
And does that tell you where it was that you recovered the items and the items that you recovered?
Yes, ma'am.
And did you do the same, did you follow the same process on these, on the projectiles and the fragments as you did with the prior projectile, that you put it in a smaller, envelope
Yes, ma'am.
with your markings?
Yes, ma'am.
And they are individually and separately, contained?
Somewhat. 5 pieces of projectile in one envelope, the projectiles in a separate envelope, and the unknown type of metals in the third envelope.
And are they in the same condition other than perhaps FDLE's marking as they were when you first collected them in November the 29th, 2010?
Yes, ma'am.
Let me show you what has been marked for identification. States Exhibit 160, 161, 161A, and 162A.
Okay.
You recognize what is portrayed in States Exhibit 160, 161, 161A, and 162A?
Yes, I do.
And are these photographs of the next section of the van that you examined?
3 of them are from the passenger door, 1 of them's from the cargo area at the rear of the van.
Judge, state moves 160, 161, 161A, and 162A in evidence?
Is there any objection other than previously discussed?
Nothing other than what we previously discussed.
They'll be admitted at this time.
Okay, what area of the van are we seeing in 160?
That is the interior side of the passenger's door.
And did you do the same thing with this door as you had done with the other pieces of the van and removed this red lining?
Yes, ma'am.
And once you removed the red lining, did you uncover or did you recover any casings from that area?
It would not have been casings, it was one projectile.
Projectiles or from that area?
Yes, ma'am.
161, what are we seeing there?
That's going to be a projectile, if I'm not mistaken.
It's gonna be what?
A projectile.
And is that this same area with the red lining removed?
Yes, ma'am.
And is this the projectile that you located on that door?
It was inside the door. We couldn't get a camera down into it, so we pulled out and photographed it.
And do we have a closer photograph of that same projectile?
Yes,
Or I
ma'am.
call it a casing again. And is that the projectile that was recovered from that area?
Yes, ma'am.
161B marked for evidence and ask you to examine it. And once again, the outside envelope does not have your markings. Do you recognize the item that is contained within State's Exhibit 161B?
Yes, ma'am.
And is that the projectile that you recovered from the passenger front door, as we've seen photographed in 161A and 161?
Yes, ma'am.
And is it in the same condition as it was when you first recovered it?
I could not tell you that. It's in the sealed envelope.
The
The envelope is, other than the fact FDLE added their own tape and inventory numbers on it.
And other than the FDLE's markings, is it in substantially the same condition, the envelope, as it was when you first put it in evidence?
Yes, ma'am.
Your Honor, the state will move State's Exhibit 161B in evidence.
Other than previously discussed, any objections?
No.
It'll be admitted.
And did you continue searching the van for additional projectiles?
Yes, ma'am.
Let me show you 162 and 162A. Do you recognize what's being portrayed in those two photographs?
Yes, it's the rear cargo area of the vehicle, and we photographed projectiles.
And they appear as they did when you photographed them back at your shop?
Yes, ma'am.
Your Honor, the state will move 162 and 162A in evidence.
Other than previously discussed, any objections?
No.
They will be admitted at this time.
What is it that we're seeing in 162?
That's going to be the rear cargo area where the wheel well is.
The same wheel well, yes, I can speak English. The same wheel well where you had originally recovered the projectile? The same type of...
Yes, trying to think about flipping it over. I believe it is.
Okay. And did you remove the lining as you had with the other items that we have seen?
Yes, ma'am.
And did you in fact recover any projectiles? Or
Yes, ma'am.
162A? What is it that we're seeing there?
It was 2 projectiles recovered from that cargo or cubby area and 1 piece of projectile.
recognize what's in State's Exhibit 162B as the pieces of projectiles that you recovered from the passenger side cargo area?
Yes, ma'am.
And just like with the others, they're in, when you took them into evidence, you put them in the smaller envelope
Yes, ma'am.
with your markings on it?
Yes, ma'am.
And other than FDLE's markings on it, they're in the same condition?
Yes, ma'am.
Your Honor, this time, the state will move 162B in evidence?
Other than previously discussed, any objections?
No.
They will be admitted, or it will be admitted.
Did you continue searching the van for additional projectiles?
Yes, ma'am.
It'll help if I show them to you first. Let me show you 163, 163A, and 163B, and ask you if you recognize what's in those photographs.
Yes, ma'am, I do.
And do those photographs depict another area of the van and the projectiles that you recovered from that same vehicle on November the 29th?
Yes, ma'am.
Your Honor, this time the state will move 163, 163A, and be in evidence?
Any objection?
None other than previously raised.
They will be admitted at this time.
163 is showing us what part of the van?
It's the interior of the sliding glass, no, the sliding door of the vehicle.
And once again, we're seeing the red lining with some indentations and holes on them.
Yes, ma'am.
Did you remove this lining as you had with the other pieces of evidence? I mean, of the other pieces of the van?
Yes, ma'am.
And did you in fact recover any projectiles or fragments from that area?
Yes, ma'am.
Let me show you State's Exhibit number 163A. What are we seeing now?
That's the sliding door from the van with the plastic cover removed. You see one of the projectiles that we recovered over on top of the
Right.
door.
And did you, and it's one projectile is readily visible on the exhibit.
Yes, ma'am.
Did you recover more than one projectile or fragment from that area?
Yes, ma'am.
And what did you recover from that area of the sliding door?
I believe it was one piece of a fragment, and possibly I believe it was 4 projectiles.
Okay, let me show you State's Exhibit 163B. Is that a photograph of the projectiles and fragments once you remove them?
Yes, let me make a correction. It's going to be 5 projectiles and 2 pieces of projectile.
Okay, so it's 1, 2, 3, 4, 5, and
Yes,
these
ma'am.
2 are the
Yes,
pieces? Okay, now I really get to show you 163C. That you've previously seen this one, right?
Yes,
This is the
ma'am.
one where I showed you originally?
Yes, ma'am.
All right. And were your markings on the inside envelope?
Yes, ma'am.
And were the projectiles and fragments inside this exhibit?
Yes, ma'am. They were in sealed envelopes.
And just as the other ones, you put them in individual envelopes with your markings, and other than FDLE's markings, they appear to be in the same condition.
With the exception of the 2 pieces, those went into one envelope.
Okay. Oh, but all of them appear to be in the same condition.
Yes, ma'am.
At this time, Your Honor, the state will move 163C in evidence.
Any objection?
Not other than previously raised.
They will be admitted.
Now, did you recover any other fragments from the van?
Yes, once the van was picked up by the wrecker, we discovered another projectile that was up underneath the van that would have been in the on the floor of the van, driver's side.
And when you say that once the van was picked up by the wrecker, is that when they were taking it away?
Yes, ma'am.
Let me show you State's Exhibit number 164. And do you recognize States 164 as the projectile that you recovered once the van was uprighted and picked up by the record?
Yes, ma'am.
And once again, when you took it into evidence, you put it in the smaller envelope with your markings on it?
Yes, ma'am.
And other than your and FDLE's markings, the envelopes are substantially in the same condition?
Yes, ma'am.
Your Honor, at this time, State will move State's Exhibit 164 in evidence.
Any other objections?
None other than previously raised.
All right, it will be admitted.
May I have a moment, Judge?
Yeah.
Thank you, Mr. Sagman. The State will pass the witness.
Cross-examination?
The pictures of them. The pictures. Photos. Good afternoon, sir.
Good afternoon.
Let me see if I can find the photos really quick.
Photos from the van at the Keetley residence?
When you were on the property on the 28th, there were many law enforcement officers there, correct?
Yes, ma'am.
And I'm going to use Defense Exhibit number 9 just because it's bigger. Mr. Zachman, if you could step down, please. Can you hold it up so that they can see? When you came out here on the 28th, do you recall that getting from Bonita Drive over to where the gate is at the Keetley home, there are either one or two other gates you go through first, or were they already open?
They would have had been already open. There were already people at the scene once I got there.
Right, so law enforcement was already present at this scene,
Yes,
correct? And they were in the process of searching this area, correct?
Not yet.
Not yet. When you got there, you all huddled together and then you decided to what area you were gonna search, correct?
We cordoned off what areas we were going to search after the warrant was read.
All right. And did you search primarily this, what I would call to be the southmost part of the area, correct?
Personally, along with other detectives, we started here, worked our way around the house. Once we were completed here, we went up here and did another search of this house.
Okay. But the van was over here,
Yes, ma'am.
okay? And by over here, we're looking at Defense Exhibit 9 over on the eastern part of the house, correct?
Correct.
In this cluster of trees?
Yes, ma'am.
Correct? All right. Did you ever go and search here on that day, down on that would be the southeastern part of the property along this tree line?
Some detectives did. I searched a little bit this way and then went up and then into the trees. Actually,
Okay.
we went up and through here and then down.
All right, so for the record, you've just put your finger that you went through the cluster of trees that we're seeing that would continue along the roadway if it went all the way back?
Correct.
And then you went through here, that, and you went toward the east and searched up here to this other tree line where there's another piece of property, correct? There was a house here,
I
right?
did not go far enough in to see if there was a house.
Okay, and it was you and other detectives, right?
Correct.
Okay. And, thank you, sir, you can have a seat. And when you're doing that, what you're looking for is anything you can find, right?
Not me specifically. I was advised, come on over, let's photograph this, let's collect this.
And when I say you, I'm, as some people say, the imperial you, like law enforcement. What law enforcement is doing out there when they're searching is they're trying to find whatever items of evidence they can find, correct?
Correct.
And you're there basically to be of assistance. You're there to, if something's found, you photograph it, you pick it up, you impound it into evidence, you document where it was, and so on and so forth, correct?
Yes, ma'am.
And then you take it over to the police property room and you turn it in.
Yes, ma'am.
And so when you were there, the only projectiles that you found was the one, while you're there, was the one projectile in that wheel well,
Yes, ma'am.
right? And that van where it was seated, I wish I could find the picture in all of this, but that van where it was located on its, basically on its roof, right? What would you call that, the roof?
Yes.
Where it's located, turned upside down, from your experience in looking at it, nobody was firing at that van in that location.
Objection, Your Honor, or calls for speculation?
Approach.
So, where that van was situated, I think when it was turned upside down, which side of the van would have been facing the Keetley house?
I believe it would have been the driver's side, no. Passenger side, if
The
not mistaken.
passenger side would have been facing the Keetley house, you think?
I believe so.
Okay, so the passenger side would have been, if you stood at the passenger side of that van and you faced west, the Keetley house would have been right there, right?
Yes, ma'am. If we could produce the photograph, I
I
could
know,
tell you
I'm-
exactly.
It's,
Do we need to take a break?
the problem is there's about 400 photos.
Mr. Gonzalez, you're welcome to look through the
Thank you.
evidence.
And so what ends up happening is that, when you looked at the Keetley house, you didn't see any bullet holes there, right?
I did not inspect the house. It was not brought to my attention.
Okay, if somebody would have said, hey, you wanna document bullet holes here, you would have taken a picture of it, right?
Yes, ma'am.
Okay. And so that van, was sitting in the area that it was, and you can't tell anybody how long it was seated there, correct?
No, ma'am, I couldn't.
It looked though like if it had been there for a long time, correct?
Yes, ma'am, due to the accumulation of leaves and that.
It had an accumulation of leaves. We also saw a accumulation of dirt, correct?
Yes, ma'am.
And we also I think you've noted that there were cobwebs, correct?
I don't know if I noted that or not.
And so you look at it, you document where it is, you can't tell how long it's been there, and you take the van over to the police impound station and put it in a secure garage where you're going to do the things you've just described to us, correct?
Correct.
And when you're there, you recover the projectiles that you did, right? And the pieces of metal and the fragments.
Yes, ma'am.
And when you recover those items, you yourself aren't able to determine what caliber, which projectiles are, or anything else like that, right?
No, ma'am.
That's something that later on maybe the Florida Department of Law Enforcement will do.
Yes,
correct?
ma'am.
You're just there to see what items of evidence you can recover from it and submit those into evidence, because that's your job, correct?
Yes, ma'am.
And when you're picking up these projectiles, whether it was the one that you saw in the wheel well when the van was still on the property upside down, or whether it's the ones that you recovered from when it was in the police garage at the impound lot, you use gloves, correct?
Yes, ma'am.
And you do that so that if there's anything to preserve of other kinds of evidence on the items you're recovering, maybe somebody's going to be able to do it, correct?
Correct.
Because you don't want to contaminate anything with your own skin cells or any of your biological material, correct?
Correct.
And when you recover these items, you can't tell, just like you can't tell the caliber of the bullet, you can't tell when those bullets were shot, right?
Correct.
You can't correspond them to any holes in the van, right?
Correct.
And you can't tell us how long they were there, right?
No, ma'am, I can't.
Voila. Let me show you what's in evidence as
If we could flip it.
States Exhibit 151, okay? From looking at this, can you tell now for sure which side of the van would have been facing the Keetley residence?
Yes, it is the passenger side.
The passenger side. And so what we're seeing like front on in this photograph is the driver's side, correct?
Yes, ma'am.
And just like with, you can't tell how long this van was there or when it got there or anything else, it also looks like it's a partial van. It's not an intact van, correct?
Correct.
And you can't tell when the cuts were made on it either, can you?
Tell what now?
When it was cut, when it
No,
was separated
not at
from
all.
whatever other piece it had with it, correct?
No, correct.
Thank you, sir. I don't have any other questions.
Redirect.
Just following up on Ms. Galvi's questions, just as you could not tell when, how long the bullets had been there or anything else, are you able to tell us the position of the van when the shots were fired into it?
No, I could not.
Thank you, Your Honor.
May this witness be excused by the state
Yes, sir.
and by the defense?
Yes, Your Honor.
Thank you, sir. You may step down. You may be excused as a witness at this time.
Thank you.
I'll ask the state to call your next witness.
Robert Durr.
Robert Durr. Mr. Durr, welcome. Good afternoon. If you'll face me and raise your right hand, please, to be sworn as a witness. Thank you. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
All right, thank you. If you'll follow the bailiff around to the ramp that leads up to the chair, please watch your step. Go ahead, have a seat, make yourself comfortable. That microphone does adjust.
May I inquire, Your Honor?
You may.
Good afternoon, sir. Could you please tell us your name for the record?
It's Robert A. Durr III.
And how are you employed, sir?
I'm a crime scene investigator with the Hillsborough County Sheriff's Office.
How long have you been a crime scene investigator for the Hillsborough County Sheriff's Office?
A little over 13 years.
What educational background do you have that allows you to become a crime scene investigator for the?
I have an associate's degree, and then I have a certificate, college level certificate in crime scene investigations through HCC. Once I was hired, I went through 9 months of on-the-job training, and I've done additional trainings throughout the years on various aspects of crime scene.
On November the 20th, and pursuant to your position as a crime scene investigator with the Hillsborough County Sheriff's Office, did you become involved in the investigation of the Guitron brothers' death that resulted in the arrest and now prosecution of Mr. Keetley here today?
Yes, ma'am.
On November the 28th, 2010, were you asked to respond to the evidence garage to process a vehicle?
Yes, ma'am.
And where is the evidence garage?
It is located on Falkenberg Road at our office.
Can you please describe for us the evidence garage?
It's a large garage area. It's air conditioned, so it's climate controlled. It's also limited access. So anything we put inside there is not open to all of the even other employees of the sheriff's office.
What type of vehicle were you asked to, and did you respond on November 20th to process said vehicle?
Yes, ma'am.
Could you please tell us what vehicle did you respond to the evidence garage to process?
It was a blue Chevrolet minivan.
Did you participate in any way, shape, or form in locating and seizing the van?
No, ma'am.
And is it customary for the Hillsborough County Sheriff's Office, once a vehicle is seized, to have it transported to the garage?
Yes, ma'am.
And is it also customary to have it followed by a member of the Hillsborough County Sheriff's Department in order to maintain chain of custody?
Yes, ma'am.
And was the van in fact secured in the garage?
Yes, ma'am.
Could you please tell us what process and procedures you followed in order to process said vehicle?
The first thing I always do is photograph the vehicle, so it's as documented as I see it when I first get there.
Let me show you for purposes what has been marked for purposes of identification as States Exhibit 175, 76, 77, 78, 79, 80, and 81, and ask you to recognize those.
Yes, ma'am.
Are those photographs of the van that you took at the garage when you first started processing it?
Yes, ma'am.
Judge, at this time, the state will move in evidence States Exhibit 175 is already in evidence. It is 76 and 77. They're all in evidence. What is it that we're seeing here?
That would be the passenger side front exterior.
$180.
That would be the passenger side towards the rear of the van.
179.
That would be the passenger side rear corner.
178.
That would be the driver's side rear corner.
177.
That would be the driver's side rear.
176.
Be driver's side front.
And 175.
That would be the very front of the vehicle.
And was that the condition of the vehicle as it was when you first came into contact with it at the garage?
Yes, ma'am.
All right. What did you do in order to process the van?
We searched the interior of the vehicle by pulling all of the items out from the vehicle, going through it, and then the detectives will tell me what they wanted collected. Anything else then is returned to the vehicle.
And prior to pulling the items of that were inside the van, did you also photograph the inside of the van?
Yes, ma'am.
Let me show you 182, 183, 184, 185, 186 as they're currently marked for identification purposes. Do you recognize them?
Yes, ma'am.
And do they represent the photographs of the interior of the van as you photographed them on November the 28th?
Yes, ma'am.
Judge, at this time, the state will move states 182, 183, 184, 185, and 186 in evidence.
Any objections?
I'd like to see them so that I can correspond.
Absolutely.
No objections other than previously raised.
All right, they'll be admitted at this time.
And the purpose of photographing the interior of the van is so that we can see what the van looked like before items of potential evidence were removed from the vehicle.
Yes, ma'am.
What are we seeing here?
That would be the driver's side front interior.
And that's looking at it from the driver's side.
Yes, ma'am.
And now let me show you 183. Is that showing the interior from the opposite perspective?
Yes, ma'am. So I'm on the passenger side of this point.
On the passenger seat, there is a red phone.
Yes, ma'am.
What type of phone was that?
I'll have to double check on that one. It was a Samsung.
And was that phone collected for evidence?
Yes, ma'am.
Let me show you State's Exhibit number 183A and ask you if you recognize it.
Yes, ma'am.
Now, when you took the phone into evidence, what do you do once you take a phone in evidence?
I wrap it in aluminum foil, and then it goes into a manila envelope, and then it gets sealed with my initials, my identification number, and the date.
And what is the purpose of putting the phone in a aluminum foil?
It's to block any signals from coming or going from the phone. So if any reason there needs to be an investigation done on a phone, it's there.
And was that done in this case?
Yes, ma'am.
And is State's Exhibit number 183 the phone that you collected from the van when you were processing it that day?
Yes, ma'am.
And is it substantially the same condition as it was, other than it might have gone to FDLE as when you first took it into evidence?
Yes, ma'am.
Judge, at this time, the state will move 183A in evidence.
None other than previously raised.
It will be admitted.
184, what are we seeing in 184?
So that's the interior of the driver's side front area, showing the edge of the seat and the front door, the interior side of the front door.
185.
So that it would be part of the rear passenger compartment and cargo area from the driver's side.
And was that was that cluttered condition as it was when you first photographed it?
Yes, ma'am.
And 186.
So that's the rear cargo area of the van, also looking into the rear passenger.
You said that earlier you said that when you were looking at the van in conjunction with the detective, items of evidence or of interest were recovered from the vehicle. Is that correct?
Yes, ma'am.
And one of the items was the phone that has already been admitted into evidence. Did you recover a firearm from inside the vehicle?
Yes, ma'am.
And where did you recover it from?
That was from under the passenger side front seat.
And other items of evidentiary value might have been taken into evidence based on what the desires of the detectives were at the time.
Yes, ma'am.
At the time, okay. Now, were you also asked to process the scene for process the van for latent fingerprints?
Yes, ma'am.
And what areas did you process and what method did you use?
On the vehicle itself, we use just regular black fingerprint powder.
And that's the one that we see on TV with a little brush
Yes.
and okay.
Yes, ma'am.
And were you able to find any, is that the only method that you used to process the entire van that day?
The van itself, yes, ma'am. Some of the other items that we took out of the van were processed with super glue fuming and then the black powder.
Right. Let me ask you this, from the van itself, did you recover any prints of potential value?
I recovered some areas of possible ridge detail. If they're value, that's determined by our fingerprint people.
In what areas of the van did you recover these prints?
From the driver's side front, the exterior of the van, and then from the driver's side front seatbelt.
And what did you do with those potential prints or items of rich value that you recovered from the van? How did you collect them?
Through tape. We use the clear fingerprint tape, which then gets is adhered to the back of a fingerprint card, and that's turned over to our identification section.
And the identification section is the one that then compares it to any other items or unknown fingerprints. Is that correct?
Yes, ma'am.
And you kind of sort of told us already, but when you are lifting a print, are you making a judgment as to whether or not they may be of value or whether they may not be sufficient for comparison?
No, ma'am, I'm not making any adjustments on that.
If there's something there, you pick it up and collect.
Yes, ma'am.
And were those the only prints that you found on the van itself?
Yes, ma'am.
And you started telling us that some items from inside the van were also dusted or printed for potential fingerprints.
Yes, ma'am.
All right, can you tell us what items you processed for latent fingerprints and what you may have recovered?
The firearm that was
Yes.
found, I was able to get fingerprints off the firearm. I was not able to get any fingerprints off the magazine from the firearm. There was a drink cup that I was able to get fingerprints on. A ginger ale can, I was not able to. There was another ginger ale can that was a Verner's ginger ale can that I was able to get fingerprints on. Then I had a Diet Pepsi can, a water bottle, or 1, 2, 3, 4, 5 water bottles that I was not able to get any fingerprints on. A Canada Dry ginger ale can I was able to, and another 44-ounce drink cup I was able to get fingerprints on.
And some of the pieces, some of the items that you're mentioning have been, were located in the, inside, I mean, all of them came from inside the van, right?
Yes, ma'am.
And some of them may be shown in some of these photographs, others may not have been.
Correct.
All right, and then we have the racetrack bottle there.
Yes, ma'am.
Another cup here,
Yes, ma'am.
a bottle here. And did you do the same thing with those prints after you lifted them and turned them over to the ID section?
Yes, ma'am.
Were you asked to test the van for the presence of blood?
Yes, ma'am.
And did you a presumptive test for blood? Well, where did you test for presumptive blood?
From the gas pedal, the brake pedal, the driver's side floor mat. There were several different stains on the floor mat. I tested all of those.
And they came back with negative results?
Yes, ma'am.
The items that you processed for fingerprints that came out of the van, as well as the testing for the presumptive, for presumption of blood, was that done on the 28th or a later time?
That was all done on the 28th. Well, the presumptive was done on the 28th. The items removed from the van were processed on the 30th. The van was also processed for prints on the 28th, though.
On November the 30th, were you also asked to process other items by Detective Schramm that did not come out of the van?
Yes, ma'am.
And what were you asked to process for prints by Detective Schramm?
Florida driver's license, a Florida ID card, and a resident card.
I'm sorry.
Florida driver's license, a Florida ID card, and a resident card.
Were you able to lift any prints from any of those items?
I did not, let's see, I processed those 3 with the super glue and the black powder, and I did not get any prints on those with that. The Florida driver's license, though, I did process with a chemical called amido black, and I was able to get 2 photographs or scans.
And what the 2 photographs or scans, can you please explain to the jury what you mean by that?
So after I processed it with the amido black, we take a photograph. You don't lift it with tape like we do with a regular fingerprint. We take photographs, or we have a scanner that we put it on. We scan the item in, and that's what we send over to the identification section.
And it goes directly to them?
Yes, ma'am.
And once again, you don't determine whether or not it has any value whatsoever.
Correct.
Now have a moment, Judge.
Yeah. Yeah.
As the witness?
Cross?
Good afternoon, sir.
Good afternoon.
So let's talk a little bit first. When you were, well, you've been a crime scene investigator how long?
A little over 13 years now.
So in the 13 years that you've been a crime scene investigator, you've processed a lot of items of evidence, correct?
Yes, ma'am.
And you've processed a lot of items of evidence for fingerprints,
Yes,
correct?
ma'am.
And sometimes you get them, and sometimes you don't.
Correct.
And that's why they're called chance impressions, correct?
Yes, ma'am.
And so there were bottles in the car, in the van, that you clearly processed, and you didn't get any fingerprints off. That doesn't mean somebody didn't touch those, correct?
Correct.
And it doesn't mean that somebody used gloves when they touched that, correct?
Correct.
And this van didn't appear to be wiped clean or cleaned in any way to you, did it?
No,
On the
ma'am.
interior,
No,
correct?
correct.
And you not only processed the van and processed items of evidence that you found within the van for fingerprints, but you also processed the van to see if you could see any indications of blood, correct?
Correct.
And you just finished talking about the fact that you didn't get any positive or presumptive indications for the presence of blood on the gas pedal, correct?
Correct.
On the brake pedal, correct? And on the driver's side floor mat, correct?
Yes, ma'am.
The firearm that was recovered was a 380 caliber, whatever that is, but it's a 380 caliber handgun, correct?
Yes, ma'am.
In this photograph here that we're seeing, which depicts, and it's Exhibit 184. In this photograph here, what we're seeing up in this dash is somebody's wallet, correct?
Correct.
And that ends up, once you take that wallet out and you take everything out of it, in fact, I think you lay everything out on a piece of paper and you take a picture of all the contents of the wallet. That wallet is Mr. Keetley's wallet, Michael Keetley's wallet, correct?
Yes, ma'am, I believe so.
And I think that you talked about, and in fact, one of the items of evidence that was just introduced was this cell phone, correct?
Correct.
Obviously, both those things were in the van when you're processing them, correct? That's why you get them, that's why you do what you do with them, and that's why you impound them into evidence, correct?
Correct.
What were the other, I think you said you had tested other identification cards that didn't come from the van that you were asked to process by Detective Schramm?
Yes, ma'am.
I want to say it was maybe on the 30th, is that accurate?
Yes, ma'am.
And who did those identification cards, you know, who was addressed on them? Who did they belong to?
The driver's license was to Juan Guitron. The Florida ID card was to Gonzalo Guevara.
Okay.
And then the resident card was for Daniel Beltram.
And you processed those for fingerprints, am I correct?
Yes, ma'am.
And did you find any on there?
I did not find any fingerprints with the super glue and back powder.
Okay. And then I think you also swabbed things in the van, correct?
Yes, ma'am.
And when you swab things in the van, you're basically trying to see if you can catch any what's called touch DNA, correct?
Correct.
And so you'll swab areas of the van, and then you get those swabs, you collect those, and you impound those into evidence, correct?
Correct.
And then it's upon the detective to send that stuff out to the Florida Department of Law Enforcement and see if they can find anything on those swabs, correct?
Correct.
Now, in addition to the ID cards that you just told us about that didn't come from the van, the things within the van and the van itself, you also at some later date were asked to process some black boots. Do you recall that?
Yes, ma'am.
Okay, and when did you process those?
Those were, oh, that's the gap. That was also done on the 30th.
That was also done on the 30th of November?
Yes, ma'am.
And you didn't find any blood on those, correct?
Correct.
Did you try to swab any of the boots to see whether or not you would get something and put in an envelope so that FDLE could check it for any kind of DNA?
No, ma'am.
And those boots looked like they had barely, if ever, even been worn, correct?
I believe so. I don't remember exactly what they look like.
If I could have a second, Your Honor?
Absolutely.
show you, thanks, Barney. I'm gonna show you, let me put it here on the Elmo, that way we can all see it. I don't know why I'm showing it to you up there. So let's look at 104A.
Objection, Your Honor.
I'm sorry?
May we approach?
Sure. This is in evidence, right?
Yes.
We'll be taking our afternoon break shortly, ladies and gentlemen of the jury.
Soon. Did you take a look? Can you see those?
Yes, ma'am.
And I know you didn't recover those. Those were brought to you and you were asked to process them. Do those look like the boots you processed?
They look like a pair of black tactical boots, yes, ma'am.
Do they look like the ones that you processed?
I don't really remember what they look like right now, but if I saw the actual boots, then I could compare the two of them together.
Okay. Let me ask you this. Did you take pictures of the boots that you processed?
No, ma'am, I did not.
And when you processed those boots, you used what's called an alternative light source, right?
Yes, ma'am.
And an alternative light source is something that you use to see whether or not you can see any stains on something that might not necessarily be visible to your eye, correct? In addition to that, you also did what to those boots?
I tested them using the same phenolphthalein presumptive test as I used on the vehicle.
And you tested not just the top of the boot, but you tested the sole of the boot, correct?
Yes, ma'am.
And all of that was negative,
Correct.
right? I don't have any other questions.
Redirect.
No, Your Honor.
May this witness be excused by the state
Yes, sir.
and by the defense?
Yes, Your Honor.
Thank you. You may step down. You may be excused as a witness at this time. Mr. Durr. And yes, ladies and gentlemen of the jury, it is time for our afternoon break. I will instruct you as previously, do not discuss the case amongst yourselves or with anyone else. Do not do any research related to the case and avoid any reports of the case outside of the courtroom. All rise for the jury. The jury has exited. Everyone may be seated if you wish. We're going to go ahead and take our afternoon break, but before we break, let me just ask, I had told them to be prepared to go up till 6, so what do you have? You're shaking your head, so no?
Judge, we have Ricky Navarro, who's the fingerprint examiner. He may take at most 30 minutes, probably less than that. We had meant to do Detective Schramm, but that is the substance of the redactions, because that was that recording's like an hour long. We have one other small witness or detective short testimony from Detective Philip Newman, but I think that's pretty short.
So no one else that we could substitute in to go longer? I mean, I'm not pushing it. If we let them go early, we let them go early. I'm more relaxed when you told me you expect to rest on Friday. I know you've got a bunch of experts that are going to be lengthy, so even if we don't rest, you don't rest on Friday, I mean, I'm still confident that we'll get this case completed within the 3-week period.
I agree.
So it doesn't look like we'll be keeping them till 6, but we will talk about whatever disagreement remains on the recorded statement. Have you all had an opportunity to make any progress?
Well, Judge, we've regressed. We've regressed to the extent that the defense is going to be asking the court to preclude the statement.
The entire statement?
The entire statement.
Based on what?
Based on the case law provided to the court, and additionally a Supreme Court case, Jackson versus State, which we will also give to the court.
I think I have it.
Obviously noting that Jackson and one of the other cases in fact preclude those statements as opposed to redaction.
And regression, I'm sorry.
And it's based along the same lines. There's no different argument. Certainly the state is going to disagree with that remedy, but that's the position of the defense as it relates to the statements in its entirety.
And regression is an interesting euphemism, since the state is agreeing to over 90% of the redactions. Essentially what it is a new position that I had never heard of until after lunch, where they now, after jeopardy's attached, after we've discussed the statement in opening, and after 9 years after it's been provided in discovery, for the first time heard that other than constitutional issues, the content is a basis for purported exclusion. But we'll address it when Your Honor wants to address.
All right, I want to look at, I have Jackson. I had obviously sent this to my staff attorney, and she sent me some stuff, so I'm going to go discuss it with her now. But when we come back after the break, we're going to pick up where we left off with the witnesses, and we'll have plenty of time. We can stay here till midnight if necessary, arguing. I don't know that it'll take that long. But
and what the procedure I'm going to suggest for Your Honor to perhaps consider before we do that is that we go page by page and let them identify everything they think is prejudicial, so you can view it in its entirety. And the opposition will tell you everything the state thinks is specifically probative of the issues before the trial. So if it is a 403 analysis, after redactions, you can make that determination.
maybe we will be here till midnight.
No, Judge, I would only suggest to the court that the redactions that lead us to the point where we think the entirety of the statement should be precluded are already yellowed, and those are those things that we think lead to that remedy. So there won't be anything more than that. If we want to take it line by line, we certainly can. I think the premise is that when you get to the point and you redact those things that should be redacted, the case law would suggest, in my opinion, that the balance of the statement is not probative, and its presidential value is certainly should be given great weight.
So what you're suggesting is that it cannot be appropriately redacted?
That's correct, 100%.
Right.
And I think the case law would give the court that remedy under similar circumstances.
And I would ask, Your Honor, when you do view those cases, to be cognizant of the fact that they found no other probative information other than the accusations of the police officers and the describing him as liars. The courts did not identify any other probative information that came from the defendant's mouth. That's not the situation we have.
And essentially you're relying on Jackson versus State, the 2012 Florida Supreme Court?
That's correct, Judge, as well as Roundtree and Gaines.
All right.
Judge, did you need Jackson or no?
Go ahead and give me it, because it's on the computer. I'm old-fashioned. I like to have a hard copy. All right. All right, enjoy the break.
Yes, sir.
Are they ready?
Yes.
Is the state ready with your next witness?
Yes, Your Honor.
Is the defense ready?
Yes, Your Honor.
All right. Is it colder in here?
Yes, it is freezing.
I'm-
As
I'm
the day,
It's
after
cold, it's
out
gone
there
on,
in the
it's
lobby.
got colder
Colder where?
in the lobby.
Oh, really?
Well,
you
the
can have
lobby
just
like the
and the
rooms.
witness rooms
I've been
are 10
hurt.
degrees colder than in here.
You should feel our office.
Hard to believe.
So Judge, they're trying to make sure the rats can't thrive.
It keeps everybody awake,
Right,
though, right?
right. That's the
Do
unsaid
not
premise.
talk about that, man. I worked here when they were running above my head doing marathons.
I remember
Yeah,
that.
yeah.
They were mice. They weren't rats. They were mice.
Whatever, they sounded like right up above your head.
I remember Judge Barber kept a head count of how many mice he killed in
had
his
it hung
office.
up in his
It
office.
increased. It was like 30 some or 40 some.
That's when he was on two when he was down with us.
I remember when you'd be in court and you could hear them calling you.
Yeah, they did. It was bad.
Lindsay Alvarez is running for
Oh,
jury
yeah,
was
in
doing jury
juvenile-
selection in
Yeah,
front of
killed one
Butler
that day.
when
I dropped
one
the
ran
book
out
on
in
it.
front of her
In
in our
juvenile
courtroom.
courtroom, middle of not jury, but middle of trial, mouse runs across, a witness jumps up on the table.
Ready, Judge?
Yes.
All right. Jury entering. Judge.
The jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, welcome back from your afternoon break. I know that we had told you, or I had told you, to be prepared to go maybe even as late as 6 o'clock today. It is my understanding that that's probably not going to be necessary. We are going to get through a couple more short witnesses and then get you home. So I'm going to ask the state to call their next witness.
State calls Ricky Navarro.
Navarro.
Ricky Navarro.
Mr. Navarro, welcome.
Good afternoon, sir.
Afternoon. If you'll come forward to be sworn, thank you. Perfect. Do you swear affirmative testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. If you'll follow the bailiff around to the ramp that leads up to the witness chair, please watch your step. When you get to the chair, go ahead, have a seat, make yourself comfortable. That microphone does adjust. You may proceed.
Please state your full name for the record and spell your last name for the court reporter.
My name is Ricky L. Navarro, Navarro.
Where do you work?
I'm a forensic print analyst for the Hillsborough County Sheriff's Office.
How long have you been a forensic print analyst for the Hillsborough County Sheriff's Office?
With the Sheriff's Office, November of last year was 18 years with the Sheriff's Office.
And did you work as a fingerprint analyst at another law enforcement agency prior to coming to the Sheriff's Office?
Yes, ma'am.
Can you tell us about your work experience and your background?
Yes, ma'am. I was hired by the Federal Bureau of Investigation and ordered to report to Washington, D.C. on September of 1969. At orientation, where you fill out all your paperwork and get your job assignment, I was assigned to become a fingerprint examiner. After the orientation, I was sent straight to class, 10 and 11-week class in the science of fingerprints, and 2 years of on-the-job training. I worked for the FBI for approximately 7.5 years. In February of 1977, I resigned from the Federal Bureau of Investigation and went to work for the North Carolina State Bureau of Investigation on March 1st of 1977. There, I worked in the latent evidence section where I examined latent fingerprints, footwear, and tire track evidence. I worked for the North Carolina State Bureau of Investigation for approximately 24 and a half years, retiring November 1st, 2001. And on November 5th, 2001, I entered on duty with the Hillsborough County Sheriff's Office. September of last year made 50 years of latent fingerprint and fingerprint work.
Have you ever been qualified, during that time period, have you ever been qualified as an expert in a Florida court of law in the area of fingerprint analysis and comparison?
In the state of Florida, federal court, criminal court, in Virginia, North Carolina, I have been qualified as an expert in excess of 400 times.
Mr. Navarro, are fingerprints unique to an individual?
Each individual's fingerprints are unique to them. No two individuals have ever been found to have the same fingerprint. No one individual's ever been found to have the same fingerprint on two different fingers. The fingerprints are unique. They are remain with that individual from birth up to death and decomposition of the body.
What about twins, identical twins?
Identical twins don't have the same fingerprints. The fingerprints of identical twins are unique to each and every twin.
And what is a latent print?
A latent print is a hidden or invisible print, one that's not readily visible to the naked eye, but one that can be made visible by the use of commercially prepared fingerprint powders and or chemicals. If you process something with a powder, then you're going to put a piece of tape over and lift it. That would be your recording of the latent print as it appeared. If it's processed with a chemical such as ninhydrin, the print in the paper or the object will turn purple in color, and that you will have to photograph to retain the image. If you don't, the ninhydrin print will disappear with time, and that photograph becomes the permanent record as what you saw on that item of evidence.
Are there different factors or variables that may affect whether or not somebody leaves a fingerprint behind on a certain item?
Yes, ma'am. A fingerprint is made when you have a transfer of substances from the hands to the object that is being handled. A fingerprint is 99.5% water, and the other chemicals are amino acids, fats, and contaminants that are on the hand that are transferred to the object. Now, if a person was to wear gloves or put a pair of socks over the hands, not allowing the ridge detail to come in contact with the surface that is being touched, then that's going to affect that you're not going to leave any fingerprints. Next is, what is the condition of the item at the time it was touched? If that item, say it was a drink can coming out of a refrigerator and that condensation builds up on a cold drink can, that's water. When that water evaporates away, it takes the 99.5% water in the fingerprint away with it. And so therefore, that's going to affect what kind of print you're going to get. Also, when the hands come in contact with the oily areas of the body, such as around the nose, the forehead, and you touch an object, then you make a transfer of those oils and fats. You can process those with powders or chemicals and get them to come up. If a person was to go into the bathroom and wash their hands, dry them really well, come back out, it's possible for them to touch something and not leave a fingerprint because they have not contaminated their hands, or their hands have not had time to build up the perspiration that is needed to make the transfer. So there's many reasons why a person can touch something and not leave an identifiable print, or touch something and the print not be left on the object. Also, it's what that object has been exposed to from the time it was touched to the time that the person gets ready to process it. That will affect the quality of the print and if you will be able to retrieve a print.
For instance, if I were to like wipe my hands on the side of my jacket and then touch this banister, is it possible my prints may not be on that banister?
It's possible that you would not leave prints on that banister because you have wiped all the chemicals and stuff off your hands before you touched it. Also, if you touch the banister and then you take your arm and lay it on top of the banister and rub it across the top, you can wipe that print away just as easy as you left it.
Okay. Now I want to ask you about identifiable prints versus unidentifiable prints. What is the difference between those?
Identifiable print means that that print has a sufficient amount of information in it that if you had a known set of inked impressions that you would be able to either eliminate or identify the individual that left that print. An unidentifiable print means that there's not a sufficient amount of information in that ridge detail that you can identify or eliminate an individual. That could be because of many reasons, and one of them would be that you have a person that touched it and then touched it again, and the print on top of a print, you can't separate the first one that was on there from the second was on there. Let's go back to the drink can. The drink can has an opening in one area. When you pick up that drink can, that hole is going to be over here toward your thumb so that you can pick it up and drink it. The hole's not going to be all the way around to the other side. So every time you set it down and you pick it up again to drink it, you're placing fingerprints on top of fingerprints. And you're not going to separate the first one from the second one or the third one that is placed there. Nowadays you have cars that's got touch screens on them for your radios and stuff to change. Well, every time you touch that screen, you're touching on top of whatever you touched before. Every time you want to change that screen, you wipe across it. You just wiped across the prints that you placed there before. So there are many reasons why you can have a print, you can have ridge detail, but it's of insufficient quantity and quality or ridge detail to make an identification or eliminate someone.
Is saying a print is of no value the same thing as an unidentifiable print?
No, a print of no value just means it's of no value. I can't eliminate this individual. I'm not saying it isn't this individual. I'm saying that it does not have a sufficient amount of information that I can identify him or eliminate him or anyone.
Sir, were you assigned to work on the case involving the defendant, Michael Keetley?
I was assigned this case in December of 2010, I believe.
Okay. And did you receive all of the latent prints that were recovered from the crime scene investigators?
Yes, ma'am.
Okay. And did that include the latent prints that were lifted from Kamini Patel from the actual crime scene?
Yes, ma'am.
Did it also include the lifts that were done by crime scene investigator Maria Ramirez from the crime scene?
Yes, ma'am.
Did it also include the lifts that were done by crime scene investigator Robert Durr of the Chevy minivan belonging to the defendant?
Yes, ma'am.
And did you also receive the latent prints that were lifted and recovered from Jason Brando from a composition book?
Yes, ma'am.
Going through those latent prints, were you asked to compare those to an individual by the name of David Beckwith?
Yes, ma'am, I was requested.
And what was your result of your analysis in comparison with the known prints of David Beckwith to all of those latent prints that you received from this particular case?
Of the latent fingerprints that were of value for comparison purposes, I compared all those latent fingerprints to Mr. Beckwith and did not identify any of the fingerprints of value as being made by Mr. Beckwith. I eliminated him as being the contributor.
Were you also asked to compare the known prints of a person by the name of Wesley Smith to all of, again, the latent fingerprints collected from all of those crime scene investigators?
Yes, ma'am.
And what was the result of your comparison and analysis?
Again, the results were that none of the latent fingerprints of value for identification purposes were made by Mr. Smith. I eliminated him as being a contributor.
Were you also asked to compare the known prints of an individual named Lonnie Tinsdale?
Yes, ma'am.
And what was the result of your analysis and comparison for the known prints of Lonnie Tyndale?
Again, I eliminated Mr. Tyndale as being the contributor of any of the latent fingerprints of value for identification purposes.
At some point, were you asked to meet Michael Keetley in court in order to roll his prints?
Yes, ma'am, I was.
And can you identify him and point him out and describe what he's wearing?
The gentleman at the defense table at the far right-hand side, my far right-hand side, wearing, I believe, what is a yellowish shirt.
Your Honor, may the record reflect that he's identified the defendant?
So reflect.
And, sir, that happened in court, is that correct?
Yes, ma'am.
And you actually rolled his prints yourself?
Yes, ma'am.
I'm going to show you State's Exhibit 116. Do you recognize this?
Yes, ma'am, I do.
And are those the rolled fingerprints of the defendant that you took yourself?
These are the known fingerprints of Michael Keetley that I took on July the 16th, 2013.
Your Honor, at this time, we'd introduce into evidence State's Exhibit 116.
Any objection?
No.
It'll be admitted.
Sir, when you receive, I think you had already mentioned that you received some of the latent prints on the computer, is that correct? There are photographs that were taken and then they are scanned and uploaded into computer, and that's how you access it?
Yes, ma'am. Some of the latent prints that were processed with a chemical called ninhydrin. Ninhydrin reacts to the amino acids in a fingerprint. When a fingerprint touches an absorbent item, that print is absorbed into it, and to get that print to become visible, you apply ninhydrin, which causes a print to turn purple in color. Now, the only way you can permanently record that impression is by photography or scanning that image into a computer system, which was done in this case. I was able to go into the Verapic Hillsborough County Sheriff's Office Verapic computer, look at the images, retrieve those images for comparison purposes.
And the reason you said that they are photographed is to preserve the evidence left by the fingerprint, is that correct?
Yes, ma'am.
That ninhydrin will eventually disintegrate, is that correct?
Yes, ma'am.
I'm going to show you what's been marked for identification, State's Exhibit 116A and 116B. Do you recognize both of these items?
Yes, ma'am, I do.
And are these photographs that were collected from crime scene Brando and uploaded into the system that had been processed with that ninhydrin?
These are the photographs of the images that were collected by Brando and placed into the Verapic computer, which I went into, retrieved, and made the photographs myself.
Your Honor, at this time we introduce into evidence State's Exhibit 16A and 16B.
Any objection?
The ones raised earlier.
I'm sorry?
The
no additional.
No additional.
They'll be admitted this time.
You did not actually receive the item that was in evidence, that was the item that was photographed and depicted in 116A and B, is that correct?
No, I did not. I just had the images that were in Verapic. I did not receive the actual item of evidence that was processed.
Okay. I'm going to first show you item 116A. And did you mark on here, is this writing that is in red and blue, your markings that you made at the time when you were making your comparison?
Yes, ma'am.
And in the upper left-hand corner, is that the fingerprint that was produced from that nihydrin?
Yes, ma'am.
And were you able to make an identification of that fingerprint, comparing it to the known prints of Michael Keetley?
Yes, ma'am, I was.
And can you tell us what the results were of your analysis?
Yes, ma'am. The fingerprint at the upper portion of that photograph, I was able to identify as being made by the left thumbprint of Mr. Keetley.
Okay. And there were enough points that were identifiable that you were able to make that conclusion, is that correct?
Yes, ma'am. The ridge detail and the pattern type. When you're making an examination, the first thing you look at is, can I determine the pattern type? I was able to determine that I was looking at an arch type pattern. An arch type pattern is where the ridges come in on one side of the finger, go toward the center, make a slight uprise, and they exit the opposite side of the finger from which they came in. Once I determined I had an arch type pattern, I looked at Mr. Keetley, all of his fingers, and the only finger he had that had an arch in it, the left hand had right slope loops. The index finger on the left hand had a right slope loop. The middle finger had a arch type pattern, tinted arch, which means it has a definite up thrust. And then the last two fingers had a left slope loop. The left thumbprint was the only one that had a plain arch. And so that's the one that I compared to the fingerprint cards, because the thumbprint had a plain arch and it had a sufficient amount of information, pattern type, ridge flow, and unique identifiable characteristics to identify.
And when you discerned that that was the only one that could possibly be it, then did you do a side-by-side comparison, and can you tell the jury how exactly you did that?
Yes. I fold the photograph in such a manner that I can fold as close to the fingerprint, the latent print that I'm wanting to look at. Then I take that latent print and I place it right next to the fingerprint that I want to compare it to. Then I place a 4-power magnifier on top of both of them at the same time. And I look at the unique identifiable characteristics in the latent and the unique identifiable characteristics in the inked impression. Now there are 5 basic unique identifiable characteristics. One is the ridge is formed into a dot. It's a dot. It doesn't go anywhere. It just formed into a dot. Then there are short ridges. A short ridge, you can see both ends of it. You can see where it started. You can see where it stopped. Then you have what is called bifurcation. That's a ridge that runs for a distance and then splits into 2 ridges. Then you have what are called ridge islands. That's a ridge that runs for a distance, splits into 2 ridges, and comes back together into 1 ridge again. These unique identifiable characteristics you look at in both of them. Then you look at the relationship of those unique identifiable characteristics to each other. In other words, if you have a dot, 2 solid ridges, and a bifurcation opening toward the right, then on the inked impression you must have that dot, 2 solid ridges, a bifurcation opening toward the right, and then you look at all the other ones, and again the relationship has to be the same.
And doing that side-by-side comparison, you determined that this print on 116A was his left thumbprint, is that correct?
Yes, ma'am.
I'm going to show you State's Exhibit 115. The composition book that was taken in this case. Does that appear to be where the print is in 116A came from?
Yes, ma'am. As you can see that the writing starting with the capital B is the same right above the capital B, and just slightly to the left is where the print is on the photograph, which is now no longer on the notebook.
So just like you said, that nihindrin has disintegrated. Is that correct?
It goes away. It disappears with time.
I'm going to show you what's in evidence now, 116B. Were you also able to make an identification on the fingerprints that were contained on states 116B?
Yes, ma'am. Examining 116B, I noted that I was dealing with a right slope loop. The individual, Mr. Keetley, had right slope loops in his entire right hand and had a right slope loop in his left index finger. The other fingers were different pattern types, left slope loops, tinted arch, and a plain arch. So I was able to eliminate 4, but I had 6 others that I needed to look at. Looking at the ridge flow in the right ring finger and the ridge flow in the right little finger, the ridge flow was inconsistent, so I was able to eliminate those. So that left me 3 fingerprints to look at. Looking at the 3 fingerprints, I was able to eliminate the right hand completely based on ridge detail characteristics, and that left me the left index finger. The left index finger, when I examined it, I noted that the pattern type was the same, ridge flow was the same, and the unique identifiable characteristics were the same, and they were all in the same relationship to each other. So it came to my opinion that the latent print on State's Exhibit
116B?
116B was made by the left index finger of Mr. Keetley.
And Mr. Navarro, I'm going to ask you to step down because there is a lot of different type of nihydrin marks. Can you come down here and point exactly which latent print that you identified to Mr. Keetley?
You may step down, absolutely.
May I pick this up?
Yes.
There's a fold mark in the photograph that I used when I folded it to make the comparison as I did before. The fingerprint that is of value, this is the right side up here, is right where my finger is pointing to. That was made by Mr. Keetley's left index finger.
You can go ahead and have a seat. And again, I'm going to show you State's Exhibit number 115. Does the other side of the page appear to be where that fingerprint was lifted on 115?
Yes, ma'am. Again, that impression has faded away, or most of it has faded away.
Some of the latent prints that you received in this case from crime scene, were some of those latent prints of no value?
Yes, ma'am.
Were some of them unidentifiable?
Yes, ma'am. The prints that were of no value, those were not identifiable, which means I could not either identify or eliminate the contributor.
Did you also receive latent prints that were lifted from any firearms in this case?
Yes, ma'am, I did.
Again, those 3 individuals that we had asked about, Michael Keetley, Lonnie Tinsdale, Wesley Smith, and David Beckwith, did any of their prints come back to any of the prints lifted from the firearms in this case?
May I look at the,
Yes, sir.
the images that I have that came from a firearm that I can tell came from a firearm were of no value to identify or eliminate anyone as being the contributor.
So you cannot tell, is that correct?
That is correct.
Your Honor may have one moment.
Absolutely.
Your Honor, this time we pass the witness.
All right, cross-examination.
Ms. Dowdy, do you want this?
Good afternoon, sir.
Good afternoon.
How many prints of value did you get?
Prints of value?
Yes, sir.
In the first envelope, I had 5 latent prints of value for identification purposes. But this is an envelope that I had, envelope marked as number 1.
Okay, let me look at those. Were these yours in evidence? Do you know?
These were the ones that were given to me in this comparison. For this comparison, they were lifted by Patel.
Okay. And of those that were of value, they were lifted by crime scene investigator Patel. Were you able to identify them to anybody?
No, they still remain unidentified.
Okay, so you would have certainly compared those to Mr. Keetley, correct?
Yes, ma'am.
And he was not identified as being responsible for any of those prints, correct?
Mr. Keetley did not make any of these 5 latent prints of value.
Okay. And on those cards, can you tell where those items came from? Where those prints came from?
Only by what the crime scene person wrote on. It's the only way I would know where they came from.
Perfect. All right. And so then, were there other, besides those that were in your envelope 1, were there other prints of value other than States Exhibit 116A and B, the prints that came off the composition notebook that you've just talked about? Were there other prints of value other than those 5?
That's envelope number 1.
Okay.
Okay. Envelope number 2. Contain 10 latent impressions of value for identification purposes.
And who were those represented to have been lifted by?
These were lifted by Ramirez.
By Maria Ramirez?
Yes, ma'am.
Okay. And none of those came back to Mr. Keetley, correct?
Correct.
All right. And do you have another envelope that might have latent prints of value?
The envelope that I had marked as envelope number 3, there were no latent prints of value at all in that envelope.
Okay.
In envelope that I had marked as envelope number 4, contained 2 latent fingerprints or latent impressions of value for identification purposes.
And who were those represented to have been lifted by?
Durr.
Crime scene investigator Durr?
Yes, ma'am.
Okay. And did any of those come back to Mr. Keetley?
Yes, ma'am.
And was that the one that was represented to have been lifted from a race track like cup inside a minivan?
Racetrack 32-ounce drink cup.
Okay. And was there another print of value that did not come back to Mr. Keetley?
Yes, ma'am. There was one more that did not come back to Mr. Keetley. It's still unidentified.
Okay. And do you have any other envelopes that might have latent prints of value?
Envelope number 5 that I marked as 5 were VeriPic images that I retrieved from the computer system. Did not contain any latent impressions of value for comparison purposes. Envelope number 6 was envelope that did not contain any latent prints of value for comparison purposes. Envelope number 7 again is a VeriPic envelope containing images from the computer. No latent prints of value for comparison purposes. Envelope number 8 did not have any latent impressions in it at all.
Okay, so there were lifts, but when you looked at it, they weren't any latent prints at all there.
No, ma'am. There was the envelope was marked shoe card.
Okay.
I don't know whether that means a footwear impression or something that the crime scene person saw and made a note of it.
Took a photo of it. Took a photo of it?
I don't know if he took a photo or not.
Okay, go ahead.
And then the last envelope I have was taken by Jay Brando. It contained VeriPic images. Again, they were of no value for comparison purposes.
And did that conclude your involvement in this case, sir?
Yes, ma'am.
I don't have any other questions. Thank you, sir.
Sorry. Redirect?
Just briefly, Judge. Sir, going back to those different envelopes containing the different lifts that were done by crime scene, you were not there when those lifts were done, is that correct?
I was not.
But on those different envelopes, it tells who the crime scene investigator is that took them and gives some kind of description where the print was taken from, is that correct?
Objection to leaving.
I'll sustain. Rephrase.
What information is contained on the latent prints that you received from this in this particular case?
On the latent lifts, the envelope first is marked as who lifted it. For example, envelope number 1 lifted by crime scene investigator K. Patel, gives an address of 406 Ocean Mist Court. And then on the back of the latent lifts that were lifted by her gives that same address and other information that she had written on them.
Okay. Can you give us the other description of where those prints came from? Of the ones that you said were of value or you could not identify?
Okay. On the ones that that I have of value, the one card that I marked as 1/1 indicating that is the envelope 1. It was the first lift in that envelope. It contained a palm print of value. It says interior side of front entrance screen door. The envelope, the card that I have in my hand that says 1/2, indicating again from envelope 1, lift number 2 that I had taken out and marked says exterior side of front passenger door Chevy van.
Okay.
The card that, I'm sorry, I need to go back to the first one was actually card number 1/3. 1/1 contained 2 prints of value for identification purposes, and that one says interior side of front entrance screen door, just like 1-3 had.
Mr. Navarro, you were never given any of the residents to that location to compare to any of these prints, is that correct? Other than the 3 individuals that I asked you, you weren't given any known prints of anybody that lived at 604 Ocean Court Mist, is that correct?
No, other than the names that were mentioned here, those are the only ones that were given to me for comparison purposes. Anybody that lived in that house or had been to that house, I was not provided with their prints for comparison.
Okay, and as you've already testified, is it possible to have touched that screen door and not leave a print behind?
Yes, ma'am.
Or touch a car and not leave a print behind?
Yes, it is possible.
Going to envelope 2, just so it's clarified for the record, because you said that there, I believe, were 2 prints of identifiable value. Again, can you give us the description of exactly where those prints were located? I believe you said it was crime scene investigator Ramirez.
Yes, ma'am, it was. On the envelope, it indicates 406 Ocean Mist Drive. And I believe on that one I had 10 fingerprints of value. On lift that I have 2/1 indicates it came from exterior hood Nissan, gives a VIN number. On lift 2/2 contained 3 latent fingerprints of value. That came from exterior hood of Nissan, and again gives the VIN number. On 2/4 has 1 fingerprint of value for identification purposes, exterior hood of Ford, and gives the VIN number. 2/5 had 1 latent palm print of value for identification purposes, and it says came from exterior hood Nissan, again with the VIN number. 2/6 contained 1 latent palm print of value, came from exterior driver's back door Dodge, then gives the VIN number. On the last one is 2/8, and it says it came from exterior hood Ford, and gives the VIN number.
So all the ones in envelope 2 from Ramirez notate some kind of lift from a vehicle, is that correct?
Yes, ma'am.
Okay. Can we go back to envelope 1? I think I stopped you, there were 5, and I think I stopped you at 4. Can you tell us what that 5th one was?
The 5th one was the on the card marked 1/1. That one contained 2 fingerprints of value.
Okay, so there were a total of 5, but only 4 cards.
Yes, ma'am.
Now going to envelope 3, I believe you said that that was an envelope that had no prints of value, is that correct?
That is correct.
But could you tell us who the crime scene investigator was and where those latent prints, what was the description provided?
These were lifted by crime scene DER. Location says CSS for crime scene search. They were of no value, and the indicates on the cards that they came from. One was from driver's side, front door, exterior, doesn't give the make or model of a vehicle, and driver's side, front seat belt, driver's side, front door, exterior, and the last one was driver's side, front door, exterior.
And then envelope 4.
That envelope contained 2 latent prints of value for identification purposes. It was lifted by crime scene investigator DER. Location says CSS again. The card that I have that says that has 4/1 coming from envelope number 4. That is the one from the racetrack 32-ounce drink cup that I identified as being made by Mr. Keetley. The other one contained a latent, a fingerprint of value. That one indicated it came from Canada Dry ginger ale can.
And then going to envelope 5, was that another envelope where there were no prints, no latent prints of value?
Yes, ma'am, that was a Veripic envelope where the images were loaded into the computer, and I went in and examined them and determined there were no latent prints of value for identification purposes.
As part of those uploaded images in Veripic, were there also descriptions of who took those latent prints?
The envelope indicates the crime scene DER did the processing. Location again is CSS. The images that I retrieved out of Veripic, I had labeled as 5/1, 5/2, and it says backside of Florida driver's license.
And then envelope 6. And again, it doesn't mean that nobody touched those driver's license. There just were not any prints of value. Is that correct?
There was ridge detail there, but I could not identify or eliminate the contributor of that ridge detail. Envelope number 6 was lifted by Ramirez, crime scene investigator. Location says CSS. There were no value for comparison or identification purposes.
And were there other descriptions saying where they were obtained from?
On the back of the envelopes, the 2 of the envelopes indicate that it's a live round WCC 92. The other one says live round WCC 86. The other 4 envelopes say live round 45 auto, Winchester, and Federal.
And again, you weren't able to identify any of those fingerprints that we asked you about to any of those latent prints, is that correct?
Again, those prints were of no value, could not identify or eliminate the contributor of those prints.
Then I want to ask you about envelope number 7.
Envelope number 7 was another Veripic envelope, and it was processed by crime scene investigator Ramirez, location CSS. The images were images of ridge detail on 2 bullets.
Were the ridge detail of sufficient quality to make a determination?
No, ma'am, I could not identify or eliminate.
So you don't know who left that ridge detail on those bullets?
No, ma'am.
Envelope number 8.
Number 8 is the one that was processed by crime scene investigator Cashwell, and it just says shoe card.
Okay. And was there any identifiable prints on that?
There was nothing there for me to make an examination that had nothing to do with fingerprints.
Okay. And then I think there was one other envelope, envelope number 9, is that correct?
Correct, and that was processed by crime scene investigator Jay Brando, location CSS. Again, they were Veripic images. I went in and retrieved the images, made copies, and the images are ridge detail on a bullets.
Okay. Was there sufficient ridge detail to make a determination as to who left those fingerprints?
No, ma'am, they were of no value for comparison or elimination purposes.
All right. Your Honor, that's all.
May this witness be excused by the state?
Yes, sir.
And by the defense?
Yes, Your Honor.
Thank you. You may step down. You may be excused as a witness at this time.
Thank you, Your Honor.
You're welcome. It's my understanding you have another short witness.
I believe so.
All right, we'll go ahead and call that witness.
Deputy Philip Newman.
Deputy Newman. Deputy Newman, good afternoon and welcome. You'll come forward to be sworn. Wherever you're comfortable, if you'll face me and raise your right hand, please. Thank you. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. If you'll follow the bailiff around to the ramp that leads up to the witness chair, please watch your step. When you get to that chair, go ahead, have a seat, make yourself comfortable. That microphone does adjust. You may proceed.
Thank you. Please state your full name.
I am Deputy Philip Newman.
With whom are you employed?
I work for the Hillsborough County Sheriff's Office.
And how long have you worked for the Sheriff's Office?
I am in my 28th year of employment.
What's your present assignment?
I work for the court security section here at the courthouse now.
Were you working with the Sheriff's Office on November 28, 2010 at 9 p.m.?
Yes, sir.
In what capacity were you assigned at that time?
I was a detective in the Criminal Investigation Division.
Did you become involved to some degree in the investigation of the homicides of the Guitron brothers in Ruskin?
I did, sir.
And were you tasked with, were you given a specific task on November 28, 2010 at 9 p.m.?
I was, sir.
And what was that, sir?
I was instructed to go to the St. Joseph's Hospital and contact one of the victims, referring back to my supplement. The gentleman's name was Gonzalo Gazvara, if I'm saying that correctly.
Well, could you spell it for the record, please?
Yes, sir, if my spelling is correct. First name Gonzalo, G-O-N-Z-A-L-O. Last name is spelled G-U-E-Z-V-A-R-A.
Okay. And that was at St. Joseph's Hospital?
Yes, sir.
And how did you intend to collect a DNA sample?
A swab, which is has cotton on the end of a wooden stick.
Like a Q-tip, so to speak?
Modified Q-tip, sure.
Okay, and then how do you use it to obtain a sample?
What I did was the individual was laying in a hospital bed, and I simply inserted there's actually 2 of them in each pack. I inserted them inside the right side of his mouth on the inside, and just simply moved them around to collect some saliva.
Did you get any physical or verbal response from Mr. Guevara when you did that?
No, sir.
Did you have a practice, or is there a procedure for informing a person from whom you're obtaining a DNA sample of what you want to do and how it was to be done?
Normally, yes.
Did you do that in this case?
No, I did not.
Why not?
He was in a medically induced coma. He was unconscious.
Thank you. Nothing further.
Cross?
No questions.
May this witness be excused by the state?
Yes.
And by the defense?
Yes.
Thank you, Deputy. You may step down. You may be excused as a witness at this time. Let me have the attorneys approach briefly. Ladies and gentlemen of the jury, we are going to call it a day. I'm going to send you home. Tomorrow we're going to start a little bit later because I have another matter on my docket in the morning in another case, but I should be done with that by 9:30, and hopefully we'll be able to start sharply at 9:30. So you get to sleep in a little late and come in and get here just before 9:30, and we'll hopefully bring you in and get started at that time. Same instruction, don't discuss the case amongst yourselves or with anyone else. Don't do any research related to the case, and please avoid any reports of the case outside of the courtroom. We will see you back here tomorrow morning. All rise for the jury. Jury has exited. Everyone may be seated. We have one remaining thing before we finish, and that is what we will refer to as the second statement of Mr. Keetley to law enforcement. What I did is I had previously, Mr. Gonzalez, read all of the sections that you had indicated you wanted redacted, and in many cases I had to read some above and some after just to get a context of it. Since the last time we addressed this and you said you wanted now the whole thing to come out, I went back and I read all of the statement that I have in front of me here. We also, before the break, well, when we discussed it before, Mr. Pruner had indicated that you were in agreement as to as much as 90% of what they were requesting. Is that correct?
Of the redactions at that time, there's been additional requests since that time.
Well, I think I thought I heard they're now requesting the whole thing.
Yes, and then I received additional redacted requests.
Well, Judge.
After the whole thing?
Yes.
So why would there be a need to redact more if you want the whole thing out?
Judge, our position is and remains that the statement should be precluded. Certainly the court has the option to rule that the statement shouldn't be precluded, obviously, over our objection.
Okay.
In that light, as we look through the statement, as I look through the statement more, I was able to give Mr. Pruner some additional redactions that in the event the court were to not preclude the statement in its entirety, that there were other areas I believe needed to be redacted. So that's what
okay, I understand that. I misunderstood, but now I understand.
So for the purposes of the written record, and I know this will be tedious, but this second interview, for context, occurred within a car. The defendant was walked out of the interview room at D4 approximately an hour earlier and left walked out of the building, and then was not under arrest, was free to go, had no transportation, as that van was seized by the sheriff's office at the time of the stop. He was taken, agreed to go back to his home. In the car of Detective Schramm with Detective Pettis being present, he was told he could get out, he was free to go, he's not under arrest, and the scene had been secured because they were in the process of obtaining an actual search warrant. In 2010, there was no electronic search warrants, so they had to knock on the judge's door, but the scene was secure. So he chose to sit in the car, and he agreed to communicate with the detectives, knowingly that there is a
and clearly not in custody.
Not in custody, he's told throughout here. And we're here on redactions pursuant, I understand, to a request for 403 analysis, not a constitutional issue.
No, and that's what I was going to ask, because I know that you all had many hearings over the years in front of other judges. Was there ever a motion to suppress these statements?
Yes.
Argued? There was.
It was part of the stop. So there were many motions filed on Fourth Amendment grounds. And so the stop, we began with the stop and then proceeded on to what occurred afterwards. And those were all addressed and those were denied.
All right, so at some point, some judge prior to me had addressed any constitutional challenges and said, no, the statement is admissible, but now you're asking for certain parts of it. And when I read through it and I said, yeah, that's got to come out, clearly. And I suspect that hopefully those are some of the things that Mr. Pruner was in agreement to come out. So that's essentially, though, we're just not at a agreement as to what parts of it should come out, it sounds like.
Well, not
well. No, well, at some point, after considering and realizing that they're going to agree to take out some of the things that you want that are inappropriate because they're opinions of law enforcement or things like that, you've now taken the position you want the whole thing out, not for constitutional grounds, because that's been decided, but for some other grounds. So let me go ahead and hear that.
Well, Judge, if I could suggest, we have a 34-page transcript, and we need to make an appellate record, because we obviously don't know how you're going to go on this one way or the other. But an appellate record needs to understand, as we go page by page, what they are alleging is specifically prejudicial and not redacted, and I will emphasize or highlight what I suggest, Your Honor, is probative and pertinent to the trial in this case.
I'll go through. What I intend to go through is each part that they want out, and then hear from you whether you agree. You may say, we agree, and we keep moving.
Well, yes, I understand your procedure. What I'm suggesting is a step further, which is that the record reflect page 1, no redactions proposed.
Okay.
Page 2, no redactions proposed, et cetera, et cetera, et cetera.
All right, that won't be a problem. I don't mind that. But what I wanted to hear from Mr. Gonzalez before we even start doing that is his reason to take the whole thing out instead of going through and doing the requested redactions. Mr. Gonzalez?
Judge, I think that the case law would suggest that in the event and when we find that there are numerous statements made by law enforcement during the course of the interview that would be deemed to be that law enforcement officer's position on, in his opinion, as to whether or not Mr. Keetley is guilty, and many other statements that are along those same lines, essentially saying he's being untruthful, essentially saying that that he should show some remorse, essentially showing that saying that how does he want to be remembered, things along those lines. When you get to the point where those type of statements have infiltrated the interview as a whole, I think that the case law would in fact support that because there was no admission, no confession that was derived as a result of these statements and these inferences that law enforcement makes, that the balance of the statement is in fact more prejudicial than probative. And it would be my position, based on the case law that I suggested to the court, Roundtree. Gaines is a little bit different.
What was the, I left Roundtree on my desk. What was the year and what was the court that decided Roundtree?
Yes, Judge. Roundtree was a 4th District case in 2014, cited at 145 Southern 3rd, 963.
Okay.
And that particular case, the Roundtree case, is the entirety of an interview that the court determined should have been inadmissible. And essentially, a little bit different than Roundtree. Roundtree just discussed the court erring when it admitted an unredacted tape. But of course, the issue with Gaines, is that when Gaines was remanded, there would have been no reason, and certainly we don't know whether or not Gaines should have or did request that the entirety of the interview be precluded. We don't get that far. All it does is remand for a new trial based on the fact that in that case, an unredacted interview was played for the jury. In Roundtree, it's a little bit different. In Roundtree, this is a circumstance where Mr. Roundtree was appealing convictions for his armed robbery and false imprisonment. What ended up happening is that the officer interrogated Roundtree, and the entire interview was played for the jury. In the interview, that particular officer repeatedly accused Roundtree of committing the robbery, and he continued to deny the commission of the robbery.
I read it, and I mean, no disrespect to the 4th District Court of Appeal, but you have to acknowledge that the Florida Supreme Court has addressed this specific circumstance head on when they proposed 2.8 jury instruction for criminal cases. Are you familiar with that instruction?
Judge, I think that the case law also talks about those instructions not being sufficient.
Well, all of those cases are prior to 2016 when the Supreme Court drafted 2.8. So how could a 2014 Supreme Court case say that an instruction is insufficient, but the instruction hasn't been written by the Supreme Court yet? They wrote this instruction in 2016, which addresses this head on.
Well, Judge, I don't know.
Are you familiar with 2.8?
I'd like to read.
So you're not at this point familiar with 2.8?
No, I'd like to read it in its entirety.
It says this instruction was adopted in 2016. Let me read you the preamble. It says police opinions and statements regarding guilt are generally inadmissible and must be redacted from recordings introduced into evidence unless redaction would render the defendant's relevant admissions incomprehensible. If a recorded interview cannot be appropriately redacted, the trial judge must, upon request, give the following limiting instruction immediately before the recorded interview is played for the jury. And there's the instruction. It's a short instruction, but after it, it cites all these cases. Jackson versus State, Florida Supreme Court, 2012. Shepard versus State, Florida Supreme Court, 2014. So none of those cases could have anticipated this instruction and said it was insufficient. And this is what the instruction says. You were about to hear or watch a recorded interview that contains opinions and statements by, then it says, insert name of law enforcement officer, 2, insert name of defendant. These opinions and statements are pertinent only to explain the reactions and responses that they elicit. You are not to consider these opinions and statements by the police officer as true, but only to establish the context of the defendant's reactions and responses. I mean, they wrote an instruction in 2016 after all of these other cases.
Judge,
doesn't that address it though, head on?
I think it may address the entirety of an interview or the full content of a total interview if it were to be played to a jury in its entirety. And certainly, I think the question still remains whether or not, if something is redacted to the extent that opinions or those type of commentaries no longer exist, does the balance of the statement have any probative value?
What is the court? I don't have that in my book.
2.8?
Yep.
Supreme Court
Recorded
website.
interview. Well, check the current Florida Supreme Court website. That's what I'm reading from.
I know, but you said they put it in, I'm looking at my 2019.
Well, I'm reading from the Florida Supreme Court Standard Jury Instruction website, and when I pull up 2.8, the footnote on it says that it was drafted in 2016. I'm not sure why it's not in your 2019 book, and I mean, if we need to do research on that, but I'm reading it from the Supreme Court's website. But in response to your other argument regarding if it is edited, there is another instruction, and perhaps both instructions should be read, and that is an instruction on edited recording, which tells them, I'm trying to pull it up now, but my website is frozen, which tells them that you are about to hear a recording that has been edited, to take out parts that are not relevant to this proceeding, and you should not be affected in any way by the fact that it was edited. So by combining those two instructions, it sounds like I can address both of your concerns. As to not introducing the whole thing, I am not at all suggesting, Mr. Gonzalez, that there's not stuff in this that should come out. And I think that Mr. Pruner recognizes that and is willing to admit that. But there may be some parts that he's not willing to agree, and I take a look at and say, no, that comes out. But I think we can address it coming in with edited instruction, instruction on edited recording, and the instruction on recorded interview by law enforcement.
And Judge, in all candor, in looking at the book that I had, 2.8 was
Okay.
not something
I don't know why. I don't know why. I mean, if it's on the website, I'm presuming that it is still a available, and these are just suggestions, but they're standard. It's still a standard jury instruction.
Well, the Supreme Court does not publish our Florida statutes books, so they're not responsible for what's in these books.
No, but those books should have all of the standard instructions. I mean, I am looking at the Florida Supreme Court Standard Jury Instruction website, which has instructions on recorded interview 2.8.
Well, certainly my apologies to the court. Obviously,
No need to. No.
Our general instructions, obviously in the book, go from 2.7 to 2.9.
Okay, well, no need to apologize, but I suggest maybe you look at the website, and so that, don't trust me.
Sure.
Look at the website and see. I mean, I hope I'm not hallucinating and seeing this here.
Sure, the court's
I don't know. I mean, the state didn't seem to have it or suggest it.
Oh,
Judge, it's on our website.
we've had it. We've used it before.
Okay.
It's been there.
Okay.
We pull our instructions.
Well,
from
and I
the
hadn't
website.
given you much of a chance to respond yet, but I didn't hear that as part of your suggestion to address this issue. It may
Well,
be.
Redaction is recognized as the appropriate remedy, not exclusion. And there is probative information in this statement, even after the agreed upon redactions. And that's why I suggest we need to go through it.
So let's go page by page and see what the redactions are requested, what redactions are being agreed to, and then address any that are not agreed to.
And Judge, keeping in mind that as you look at your copy, we'll address the court with some additions that were discussed.
Absolutely. Absolutely.
That's
So-
page 1, I guess.
Well, but hold on. My numbers start with 522 of 1444.
There's a
Judge,
pen.
yeah, if you look at the top, Your Honor, let me find it.
The first page doesn't have
Right.
page 1, it starts on page 2.
And at the top, you'll see it goes 2 to 34. In very, very small writing, it says
Come show
Keetley
me.
interview.
I see it. Okay. All right. So even though the first page doesn't have that, we can all assume that's the first page. It starts with the date and time, November 27th, 2010 at 23:15 hours, and then it starts with a shram. All right, Tom. do we have the recorder? That's what I have and we'll consider as page 1.
That's correct, Your Honor.
All right, even though it doesn't have a page 1 on it, and it does have page 522 of 1444 at the bottom. Are you requesting any redactions on that page?
I am not, Your Honor.
All right, next I have, you're right, in the small at the top, it has Keetley interview, page 2 of 34. Any requested redactions to that page?
None, Your Honor.
Next I have page 3 of 34. Any requested redactions?
None, Your Honor.
Other than, and let me just say, you are not waiving, by saying that, I want to make the record perfectly clear that you are not waiving your request to exclude the entire thing.
That's correct, thank you.
All right. Page, you said 3 of 34, no objection, correct? Or no requested redaction.
Correct, Your Honor.
Page 4 of 34.
No redactions.
Page 5 of 34.
No redactions.
Page 6 of 34.
No redactions.
Page 7 of 34.
No redactions.
Page 8 of 34.
No redactions.
Page 9 of 34.
No redactions.
This is going smoothly so far. Page 10 of 34.
No redactions.
Page 11 of 34.
Yes, Judge, on page 11 of 34, the second question proposed by
Schramm. Through Keetley's answer, you don't really feel that way because if that's the case, none of this shit would be going on right now. Everything in between those two.
Yes, Judge. I included the following statement. Well, Mike, but you know, and I was talking about mainly for context. If we were going to
understand, I didn't see it. It's hard for me to see, but yeah, you did. You included that.
And I was just looking for flow. It wasn't that particular.
And that's
statement.
where sometimes we can do it to help things flow.
I agree with all of that proposed redaction except the very first sentence, which says, Schramm is saying, I know what the truth is. I've been on work with this case 2 o'clock.
Whoa. That's not what the first part of Schramm that I have there requesting is, you know we're here for a reason.
Judge, I think if you look at the yellow, the yellow actually, your copy probably doesn't have yellow on that first line.
Actually, I don't have any yellow, but I know you're saying I know. Okay, I see it. It's on the second line. I know what the truth is. I've been on work. I've been on work with this case 2 o'clock Thanksgiving morning. Is that what it says?
Yes, Judge.
That's what it says. But that's not an accusation of lying. That's not an accusation of guilt. There's nothing prejudicial about the detective saying, I know what the truth is. I've been working this case since Thanksgiving.
Well, Judge, if you take it in context, if you say, I know what the truth is, I've been working with this case since 2 o'clock, and then your next statement is, I know you're responsible, then I would just think that in order for it to be totally construed the right way, that that second sentence should be redacted as well.
But the jury won't be hearing the rest. So there's no construction for the jury to hear if they just hear, I know what the truth is, I've been working the case since 2 o'clock this morning. There's simply no prejudicial effect of that.
And Mr. Gonzalez, you had no objection to, you know we're here for a reason. You have to understand that, okay? What I would like to hear from you, obviously, is the truth. Up to what point were you requesting the redaction?
Is the truth, and more importantly, I know that's not in the vernacular correct English, but that period, then starting with the next line. I know what the truth is. I've been on work with this case 2 o'clock Thanksgiving morning. I'm requesting that sentence. Mr. Pruner is requesting that it stay.
But you're all right with up to, and more importantly.
Correct, Judge.
Well, that, if you leave it more importantly, just dangling,
yeah,
that doesn't make any sense.
Yeah, if I'm gonna cut it, I would cut it at after truth, before and more importantly. You see that, Mr. Gonzalez, where if I move the cut out the and more importantly.
that's fine. That would make, you know, have a little more context. And more importantly, there's a period there and it starts a new sentence, but obviously this is a transcript and, you know, as you hear it.
And as I said, my computer's still frozen, but there's another instruction on edited recording that I think is going to be appropriate once we cut this up. But we'll pass that bridge when we come to it. Anything else from the state, Mr. Pruner?
Are you contemplating redacting more than they're requesting?
Well, no, you said that if we cut it where he said, I know what the truth is, that dangling and more importantly is no reason for it. And misleading and...
I've stated my position, Your Honor.
Yeah, I know. Oh, well, I'm going to cut the, there's no reason for the, I know what the truth is. So I'm going to cut that. If you want to leave, and more importantly, I just don't understand why we would do that.
Well, Judge, I'm not arguing with your ruling, which I think I anticipate, but the legal standard is prejudicial effect substantially outweighing probative value. There being no value is really not, the determination of value is for the jury. The detective's statement, I know what the truth is, I've been working this case since 2 o'clock, there's no prejudicial value or effect to that. I'm not going to belabor the point, but I mean, you make whatever ruling, of course, and we'll abide by it.
All right. Well, that's I think that's consistent with the stuff I've read in the preliminary part of the instruction that the Supreme Court has said it's the officer's opinion that he knows what the truth is. So that's my ruling on that. But now, do you want, and more importantly, which would have led up to, I know what the truth is, or are you all right with me moving the cut back to the truth, period? What I would like to hear from you, obviously, is the truth, period.
I'm not asking for that.
Well, Judge,
Oh, you don't want that? They weren't asking for that to come out, so it's there.
I'm not requesting that redaction.
Yeah, no, okay. I mean, I don't expect you're requesting any redactions. All right, so that's where the cut is then.
That's correct, Your Honor.
After truth.
Down through.
All right, well, I got to make sure because they're the ones who are going to give it to their people in the morning to
Yes,
do
sir.
this.
Yeah, so it starts, the redaction starts with, I know what the truth is. Is that correct?
No.
And more importantly, is coming out because.
Okay.
So truth is going to be the last word.
Okay.
All right. And that was the only part that you were disagreeing with all the way through, well, Mike.
Yes, sir.
All right. So I'm going to, you all are in agreement. So whatever you're in agreement on comes out. So the rest of it comes out up to well, Mike. Through well, Mike. Anything else on that page?
No, Your Honor.
Next page I have is 12 of 34. You have all of Schramm's that you're requesting, first paragraph?
No objection.
Mr. Gonzalez, you want all of Schramm?
Yes, Judge.
All right, they agree, so that comes out. You also are requesting Keetley, well, I guess they do, but, and Schramm, you did it. Is that correct?
Yes, that's correct, Your Honor.
Mr. Pruner?
We'll do it.
All right. So
Okay,
they agree.
Judge, next, if I could.
You're going to add something that wasn't
Yes,
previously.
Judge.
Okay.
If you look at Schramm, Keetley, Schramm, the next 3 entries, I've added that for Mr. Pruner's consideration. We believe that should be redacted.
Tell me, though, what's the first word of Schramm?
Judge, you've got to understand something, Mike.
Okay, I see that, but you're not requesting Keetley. You know I did not do it. I'm telling you, you're not asking for that
No,
to
you're
come
not.
out. All right. So, but you're asking for Schramm, where he starts with, you've got to understand something, Mike. I'd rather hear from you before this is over this evening. I'd rather hear from you saying, listen, I had enough, was enough. I couldn't live with it anymore. I felt like things weren't being done. All the way through. You want that Schramm, Keetley, which really is what was in between where your next previously requested redaction was. Is that correct?
That's correct, Your Honor.
What's the basis for that?
We agree to that, Judge. That's fine.
All right. Okay. So take all that out. What about the next one that they had previously requested, which was Schramm? I need to know that you've got some kind of a heart left.
We agree.
All right, that comes out. Anything else on page 12?
That would, no, Judge. And on 13, as you go to 13, we have no additions for the court's consideration. What you have there is what we're asking for.
Okay, so the first one I have is middle of the page, Schramm, understanding what I'm telling you. We don't have to do it that way. I'd rather do it with you showing some kind of remorse if I've got to do it, which you force me to do.
No objection. We'll take it out.
All right. That's gone. Going down that page, there's Schramm, Keetley, Schramm. Last part of it. Agree or disagree, Mr. Pruner?
From Schramm saying second sentence, but we can take two paths in this.
Well, what I have from them, and Mr. Gonzalez, you're always welcome to jump in and correct me if I'm wrong. What I have is, but that's the thing. We're gonna have to do what we have to do, right?
Judge, I didn't have, on the copy I gave to the court and the copy I gave to Mr. Pruner, that first sentence was not, in my mind, suggestive of redaction.
Oh, okay. So it started
Second sentence.
with which word?
But we can take two paths in this.
Okay. All right. Okay. So that first part you're not requesting, so it's not coming out. Starting with, but we can take two paths. Yes, Mr. Pruner.
No objection to that.
All right. And they had, well, were you leaving that Keetley response okay, just
Judge,
hanging there?
As I look at it, I probably would have to go back to the previous paragraph, because if there's a redaction, I don't know what he's saying okay to in the previous paragraph. I don't know whether or not it would make sense just to take out okay as that connector, because we're taking out the prior sentence. So I would ask the court and the state to consider taking out okay, because we're taking out the following sentence as well.
Well, you're requesting. I don't know if they're in agreement. Let's go ahead and go down to the next requested and then see what happens with that okay.
We agree to.
You agree to Schramm's, now you're going to be judged.
And that goes on to the top of page 14.
All right, so if we leave the first part of Schramm, but that's the thing, we're going to have to do what we have to do, right? And then Keetley's response would be okay. It would appear that his response is to that.
That's fine, Judge.
All right. And you hadn't you had not previously requested that.
That's fine, Judge.
All right, so you're with us, Mr. Pruner?
Yes.
All right. Next page, 14 of 34. I have two, which is actually the rest of what you had agreed to. It's the rest of Schramm's statement on 13.
We agree to the continuation of the redaction of the continuation of that statement by Detective Schramm at the very top, first three sentences of page 14 of 34.
All right, but then we have a Keetley all right that's not being requested, and then that's going to be hanging after the okay. It's going to be an okay, and then an all right that's really after a whole nother paragraph. So you want that out?
I'd ask that be redacted.
You all right with that, Mr. Pruner?
Sure, yes.
So take out the all right. Then we have Schramm, a whole paragraph that's requested.
No objection.
Comes out.
Judge, here's an addition for the court.
Okay.
If you look at a Keetley
But
in the
let
middle.
me stop you for a minute. Let me have one of the bailiffs go see if they can stop the hammering. Find out who's hammering. All right, I apologize.
Judge, a Keetley statement that begins with David, I've dealt with this shit with them.
I see it. It was not previously requested, but now you're requesting the entire thing or portion of it?
The entire response.
No objection.
Comes out. Anything else on page 14?
No, Your Honor.
Next, I have page 15.
Judge, the first Schramm comment, it's an entire paragraph. We're asking for redaction of the entire paragraph.
No objection.
Comes out.
We have an addition for Your Honor. In the middle of the page, a Schramm comment that starts with the state attorney and the sheriff's office, and the response from Keetley, I did not kill them. That's an addition.
No objection.
You want that whole, you want Schramm's statement and Keetley's response, I did not kill them, out?
Yes, Judge, it's an answer to the
Okay.
statement before.
They're in agreement. I'll give you a minute.
Judge, Ms. Gowdy has pointed out to me that if we look at the first Schramm paragraph that has been agreed upon,
Right.
the Keetley response, I'm sure there's a lot of cops out there that would like the things just kind of handle themselves. It's a response to that first paragraph.
You want it out?
We'd ask it that be redacted.
You all right with that, Mr. Pruner?
Sure, why not?
All right. I can't argue with that.
That's
that
it
comes
for,
out.
That's it for page 15, Your Honor.
All right. Let's go to page 16.
Judge, no redactions on page 16.
Excellent. How about page 17?
No redactions on page 17.
Excellent. 18.
18, does Your Honor show a requested redaction on 18?
I do not.
Okay, that is an addition. It would start with the Schramm statement. I told you I would not bullshit you.
All right. Let me find it. Where approximately where? Oh, here it is. Yeah. It's the top third of the page. Schramm, I told you I would not bullshit you. Okay. All right. So starting with that. And going where? How far down?
Judge, that's the entire two-sentence statement.
Okay.
Actually, it's not two sentences, it's 2 lines.
All right, but I'm concerned. I'm willing, and I want to ask Mr. Pruner if he's in agreement to that. But then you run 2 Keetley responses together without that. So we have to take a look at that. Well, let me look at the whole sentence. If I told you I would not bullshit you, okay? And you're right. I can't put somebody where they're not, but I can put you there. This office can put you there. Mike, we wouldn't be here if we couldn't. Then Keetley responds, no, you came here. The only time you're here is because I friggin' told them, and on. But if we took that out, and I'm not at all suggesting that we shouldn't, particularly if Mr. Pruner agrees, but then you see you've got the Keetley response above that. No, I mean, now if you thought you know, well, let me just try to friggin' bullshit him. And then you've got that followed by no. I don't know how that's going to look. Mr. Pruner, what's your response to Schramm coming out?
Well, we don't agree with this because it distorts the context, makes it seem something that's not. Plus, it is an accurate statement. They have one witness. Now, the idea is subject to considerable controversy by the defense, but at that point, they've got Jose Rodriguez, who's identified the defendant, again, by one photo. But there's nothing inappropriate with that statement.
Yeah, well, what is your reason, Mr. Gonzalez? I'm not sure that. I mean, I'll allow you an opportunity, but
Judge, I can't dispute that at the time that this interview was taken, that
Okay.
they did not at least have a tentative identification of.
all right. So I'll deny that additional request to take that Schramm statement out. I'll deny that.
That is the balance, Judge, of that page.
Page
18.
19.
Judge, in the middle of the page, and I don't think it's an addition, Schramm says, Mike, I know you did, buddy. You can deny it all you want. That entire 2-sentence.
No objection.
All right, comes out. Makes it easy, Mr. Pruner. Thank you. Anything else?
Judge, can we have a moment?
Yes. We'll call this an addition to the additions. Found the hammering? Mr. Gonzalez?
Judge, I forgot where we were. We're on 19.
State agreed to the middle of 19 Shrams. Mike, I know you did it, buddy. You can deny it all you want. State agreed. Mr. Pruner agreed. So it comes out.
Nothing else on 19.
Next page I have is 20.
Judge, no additions on 20, but we'd be looking at the middle of the page, paragraph that starts with a Schramm comment. I'm not going to speak of what I don't know. And that's the entire paragraph.
And let me just make sure, because then you have, it looks like you're not requesting Keetley's, I don't think, and then you're not requesting all of the next paragraph of Schramm. You're all right with the first, essentially, sentence up to, except for this shit. It's after that you want the rest of the paragraph. Request redaction starting with you. Yes. Mr. Pruner, what's your position on those two Schramm?
As to the first paragraph, it's the state's position that the first three sentences should not be redacted, and specifically what should not be redacted in our view is, quote, I'm not going to speak of what I don't know. I don't care about the phone. That's meaningless to me. The phone's meaningless to me. I personally can put you there. I've been working this since 2 o'clock Thursday morning, and there's so much more that I have that I would love to tell you, but I'm not going to tell you. There's absolutely nothing inappropriate with that. It's his, the detective saying the phones don't matter to him. I can put you there. The rest of it is, quote, as long as you sit there and keep denying it until the end of that paragraph, I don't oppose. Those first three sentences, I suggest, are permissible.
All right, but you in agreement to the rest?
Well, of that one paragraph.
Okay. All right. Mr. Gonzalez, as to that the state agrees with, what's your position?
Judge, we'd ask that the entire paragraph be redacted.
This is different than the truth one that I